Okay, let's continue with Rule 611. So remember, 611C generally says that there's no leading questions on direct, but it's okay on cross-examination. But what they really mean is of a non-hostile friendly witness, because that's who you usually question on direct. Or on cross-examination, you can go ahead and lead because it's usually of a hostile or adverse witness. Remember, leading questions are okay when we're talking about basic background or undisputed facts, or helping along an infirm or child or forgetful witness. 611B, we've already discussed how that must be within the scope of the direct examination, unless you can get the judge in her discretion to let you ask questions beyond the scope, such as when the witness is going to be gone from the trial, and so you don't want to have to subpoena them again for the second time. Then, form of the question objections really come under Rule 611A. There are many of them. I won't go through all of them, but just to give you an example of some of the more common ones. A compound question. You can't ask someone, did you go to the store, and then after that, did you go to the movies, and then after that, did you come home and go to sleep? That would be objectionable compound. Ask each one of those questions one at a time, because it's unclear how the witness is going to answer, or if you ask in a certain order. The answer to all three of those questions could be yes, but they could be in a different order, and so it would be misleading. And notice, for these objections, you're not saying the information itself is inadmissible, only that the question was asked in an improper way. Assuming facts not in evidence, so if you ask a question that inherent in the question, there's already a fact that is assumed, then that's no good. The typical one, or the iconic one, is, when did you stop beating your wife? The question was when, but it's assuming the fact that the person beats their wife. Now, if there's already evidence in that the person beats their wife, then asking them, when did you stop beating your wife, would be perfectly valid. Argumentative. In some senses, all leading questions are argumentative, in the sense that they're suggesting an answer and they're telling a certain story. But you can't go over the line where you start to quarrel with the witness, or you are starting to make quarrelsome statements in the form of a question that go overboard. And again, it's just a way to rephrase not to do that. So if you were to say something like, so before you were negligent, you were drinking, or something like that, where it's too argumentative, in the sense that you are making more of a legal point in the form of a question. So you'd have to rephrase and save the argument part for closing argument, where it would belong. Non-responsive, that's just where the witness does not answer the question that you've asked, so the questioning attorney gets to object as it being non-responsive. Usually the questioning witness doesn't get to make the non-responsive objection, because they're being non-responsive, but it's not to their question, it's to the other attorney's question. Although some judges will allow either side to make a non-responsive objection. The other one is narrative, and people on direct examination will sometimes do this. They'll just ask a very general question, tell us what you know about this incident, or what did you do that got you involved in this lawsuit? Something that isn't a specific question, but is a very general one, so that the person could go into a long, long story, and then the other side never knows when to object, because they don't know what's coming next. The whole idea with direct questions, even though they're open-ended, is that you at least know what's coming next, and probably there's no objectionable evidence coming based on the question. So it's narrowly tailored enough where you can make objections, not so general where you say, tell us everything you know about the dispute. Okay, then moving on, we did 610, which was religious credibility issues. So, and 611 are the ones we just finished. 612 is when you can use a writing to refresh recollection of a witness, of, let's say, a forgetful witness. And the whole idea is that you refresh or spark their memory. Now, the writing that you use is not itself admitted, and the reason is because it's not evidence itself. The testimony of the witness, the refreshed memory of the witness, and then their testimony is really the only evidence. So let's say I am asked, what did we cover in the review session? And I can't remember. And they'll say, well, would seeing an outline of the PowerPoint presentation help you remember? Yes, it would. Okay, please look at this presentation and read it to yourself silently and let me know when you're done. I read it to myself silently. Oh, okay, yes. Has that sparked your memory? Yes. Do you now remember what you covered? Yes, I do. Could you please let the record reflect that we're pulling away the document? You no longer see the document? Yes. Could you tell us then what we covered? Oh, we covered witnesses, relevancy, blah, blah, blah. Then I would testify. It's not hearsay, it's not evidence, because this is not evidence. This isn't what's testifying. This, my memory, what I'm doing, my talking and testimony would be what was testifying. So that is why we can refresh recollection. Now, this is something you do with a friendly witness. You usually won't, not when you're cross-examining somebody. If you're cross-examining someone, you're trying to, hurt their credibility a little bit. Refreshing their recollection doesn't do that. This is more of a friendly technique to help a friendly witness remember something. It could be done in a less friendly way or almost in a sarcastic way if you're really trying to poke at the person's inability to remember, but you don't want to be a jerk about it, and you're always having to refresh their recollection. Maybe with an older person, you want to show them respect, so you don't want to accuse them of lying or embarrass them, but you still want the jury to know that this witness can't remember very well. And so you're still attacking their memory, but you're doing it in a less adversarial way. That can happen sometimes. Remember, this is not brought in as evidence, the writing used to refresh the recollection, although it's possible if the other side wants to use that and put it forward, then they can do that, just to make sure that there are no special written notes on the writing that's used to refresh a recollection. And anything can be used to refresh recollection. It could be a song, it could be a smell, it could be a poster, anything like that. Usually they'll say a writing, because it's usually a document, but it could be anything. Note also, too, now remember when we said with Rule 611 you cannot ask leading questions, but one of the exceptions being non-controversial, undisputed issues, background issues, or helping a forgetful witness. So you can sometimes read and ask leading questions of the document that you're using to help refresh the recollection. Now contrast that with Rule 613, where we're actually going to go in and impeach the witness with a prior inconsistent statement made by the witness. So the witness can always be asked about what they allegedly have said in the past. It often is in a deposition, but it doesn't have to be. It could be in an email, a letter, something that they just said to someone in a phone call, whatever it may be. The one thing about this to remember is that at some point, if you're going to use the prior inconsistent statement as an admitted document, you have to let the other side, or you have to give the witness a chance to explain it. Now, you don't have to reveal to them at the beginning that you have a prior inconsistent statement, because then the witness would know when to lie and when not to lie. If you had to reveal it at first, then they would say, well, these areas, they have my statement, I can't lie, but these other areas, they don't, so I can lie. That's why the rule says you don't have to show them at first, but eventually you have to give them the chance to do that. So if this were the document, again, if it were a document saying that I was at the meeting, the February 19th meeting, and I'm saying now that I was not at the meeting, they could get all that information out, and then they could show me this document where it's the letter. And then they would read where I said I was at the February 19th meeting. And then I would stop, or the questioning witness would stop to say, all right, now it's clear what the inconsistency is. And later, in closing argument, you'll argue that the person was caught in a lie or it was inconsistent. And remember, it's not hearsay because it's not being used for the truth of the matter asserted. If you do want to use it for the truth of the matter asserted, then you would have to use, it would have to fit 801 D2A, which is a prior inconsistent statement made under oath at a trial, hearing, deposition, or other proceeding. Another example of this would be, and I'll just put it forward so you can see it a little bit easier, but assuming the witness is Mr. Jameson. Mr. Jameson, you testified on direct that you have never been late to work. Is that correct, sir? And he'll say yes. And you remember giving your statement in this case, don't you? Yes. In fact, you signed the statement under oath, making it an affidavit, correct? Yes. That means you swore under the pains and penalties of perjury that what you said in the affidavit was true, right? Okay, this is just setting it up. It's like re-accrediting what they said previously, and it's getting him to acknowledge that what he said was truthful, that there was no reason to lie. He signed under oath. It was it was in an affidavit, kind of like really setting this person up. You made that statement before you came to court today. Isn't that correct? Like it was later in time when he made that, I'm sorry, it was earlier in time when he made that statement when his memory was more fresh, right? When your memory was more fresh. At that time, you swore to tell the truth in the affidavit. All of these is sort of like cornering a person to make them see, oh, we're going to get you with this prior statement. And so you had no reason to lie when you signed your affidavit, right? Right. Mr. Jameson, I want for us to take a look at that sworn and signed affidavit of yours in this case. Is that okay? Yes. So we look at the signed statement. We pull it up. Say, may I approach the witness, Your Honor, Mr. Jameson, and you give him a copy of it. Starting at the top of the statement, please read silent to yourself while I read aloud. Right? And so it would go on. Because I have to commute to work, I may have been late to work a few times. Once I overslept my alarm and arrived to work 20 minutes late. I'm not sure anyone realized I arrived late. Another time, I got into a fender bender and arrived 45 minutes late. Roger only warned me not to be late again after the second incident, right? Now, I read this first part correctly, didn't I? Because they have to say you read it correctly. It's right there, the jury can see it. And that was your signed and sworn affidavit, correct? Thank you. And now you've set it up. Now, again, you could argue that it's hearsay. Now, although it's under oath, it wasn't at a it wasn't at a trial, hearing, deposition, or other proceeding like a grand jury indictment. So it couldn't come in for its truth, but you could use it to show that they say different things at different times, and therefore you've impeached them or you've caught them in a lie. You don't ask anything else, because if you ask anything else, that gives them a chance to explain it away. Now, they will get to explain it away, and they're confronted with this, and their attorney will have an opportunity, maybe on direct examination, to explain it away. And if you want this statement to be admissible, then they have to have that chance to explain it away. Now, hopefully it doesn't matter, because, whatever their explanation is going to be, the bottom line is it's still inconsistent, and you still will have made your point, and it'll seem like anything they say, they're just trying to weasel out of it. Okay, now let's go to lay opinion testimony. And this is the 700 series, and both lay and expert opinion, the opinion must be helpful to the jury. That's a key element, because in both of these instances, the jury can come up with their own opinion. The opinion of the jury is their verdict. The opinion of the jury are all the inferences that they draw from the facts that they look at. So the jury doesn't need help, usually, making inferences. Because the jury can do that all on its own. What the jury needs help on is for the witnesses to relate the facts that they've witnessed. But there are two exceptions where opinion testimony can come in. Rule 701 is lay opinion testimony, and then Rule 702 to 706 deal with expert testimony. So we know in these situations, usually it has to be helpful to the jury. And before we even get to lay opinion, remember that part of an expert's opinion as to why what they're saying is helpful to the jury is because the jury doesn't know about certain scientific or technical areas. And so if a typical jury doesn't know that, then we can allow an expert to lend their expert analysis to try and help the jury understand something. And we saw that you see that in the Fry and the Dauber case. And the question is, how do we allow in good, valid expertise and science and simultaneously keep out junk science or quacks that don't know what they're doing? And so in doing that, that's where we have to deal with expert opinion. And should we have more expert opinion testimony at trial because jurors are incompetent or uneducated? There's some policy that maybe we should do that. But other people who think, no, this is part of our democratic system and that you have to be able to convince lay jurors of this, and we don't want trials to become just battles of the expert. Well, anyway, let's go to Rule 700 and deal with the opinion testimony. First, one of the things like I was pointing out before, the witness must be competent, the witness must have personal knowledge, right? We're under Rule 602. And so we want them to have witnessed something. That's why we call them a witness. We don't want their opinion. We don't want their inference. We're leaving that up to the jury so that the jury can ultimately give their opinion. So the starting point is that opinion testimony is inadmissible. There are these exceptions, but generally it is inadmissible. Why? Because we want witnesses to only tell us what they actually witnessed, hence given their name of being witnesses. Now, the two exceptions are provided for in the 700 article. First, Rule 701, lay opinion testimony as to certain impressions that a lay opinion witness may have. There's a strong 602 requirement, a 602 personal knowledge requirement. But examples of these would be whether a person appeared to be drunk. Now, the witness who sees the person that appears to be drunk, they're not an expert doctor. They don't give them a blood or breathalyzer or alcohol test. They don't do a blood test. They're not doctors that can make that determination as a clinical matter. But they can still, given their experience, come to a conclusion or inference that the person was drunk based on how they were acting, based on having seen other drunk people. And it's helpful to the jury because instead of just explaining what they saw in terms of the person was stumbling around, they were slurring their speech, their eyes were bloodshot, they could do that, but it's also helpful to give the inference that they appeared drunk. because somebody who is sick or has the flu could also have those symptoms. But to be able to say, well, they both stumbled around, they both slurred their speech, both of them had bloodshot eyes, but this one appeared to have the flu and this one appeared to be drunk, that helpful conclusion that goes beyond merely what you articulated that you saw, but the inference you got from the totality of the circumstances, that is a helpful conclusion for the jury to look at. And it's of a lay person because this person is not an expert, but in their common day, everyday experiences as a lay witness, they can come to certain conclusions. How hot was it? It was 95 degrees about. Now, they don't know if it was actually that much, but it's much better to give that kind of guess opinion, it was 95 degrees, than if you tried to just say how hot it was and people were kind of sweating. And, you can't really give more specific information, but giving the opinion allows you to be more helpful to the jury. So that's what we allow you to do. Again, huge exception for the type of testimony witnesses are supposed to give at trial. Again, witnesses say only what they know under the 602 requirement for personal knowledge as a factual matter. Remember, the jury's the fact finder. They listen to these witnesses, find the facts, and the verdict is essentially just their best guess as to what happens. So the jury forms an opinion. And so the jury doesn't need another opinion, usually. But if it's helpful to the jury, then we will allow it under these exceptions. So yes, witnesses should not just give their opinion if it's not going to be helpful to the jury, because the jury can do it for itself. So like if you tell a juror that how fast someone was driving and what they did when they came to the intersection and did they look both ways, that's all fine and well. If the witness says, and in my opinion, the person was negligent because they ran the red light, no, that's inadmissible. The jury doesn't need that, because the jury can come to that conclusion, that opinion, that inference on its own, based on all the factual information that is articulated to it. But if something escapes full articulation, where the only way to fully explain it is to give the shorthand opinion, oh, this person appeared drunk, this person appeared to have the flu, this person appeared angry, this person appeared as though they were lost, then that is okay. Now, watch out for legal opinions that shouldn't be coming in there. This person seemed so lost that they weren't paying attention, and they therefore were open to being negligent. Now you're putting too much into it as a layperson, and you're trying to put legal buzzwords in there. That's not helpful to the jury, because the jury can do those things on their own. But how old somebody appeared to look, did they look over the age of consent, let's say, or whatever it may be, that is something that can't fully be articulated, and therefore it would be helpful to the juror. Okay, now for expert testimony, right? They're just basic ideas, and we want to give our expert opinion. Remember that an expert first has to be qualified in a certain field of expertise that allows them to give their expert opinion on an issue to the jury that is beyond the regular juror's knowledge. Now, notice, it's helpful to the jury in that way. It is true that an expert witness does not have personal knowledge, right? Personal knowledge is not required. Maybe they didn't see the accident. They didn't see anything. They're just getting factual information the same way the jurors are. But they're telling the jury how they can analyze those facts better if they use a certain field of expertise. So an accident reconstruction expert, they can come in there and take skid mark measurements and the crash analysis of the car. And although you could give that to a jury doesn't have accident reconstruction analysis abilities where an expert does. So an expert can help interpret that information. And so it's helpful to them in that way. Now it's different than a lay opinion, where in lay opinion, the helpfulness is that the witness was there, perceived something, they can't fully articulate it, but their opinion would be helpful to the jury in understanding, for instance, that the person was drunk rather than had the flu, right? But that's a different kind of experience that's involved. That's lay, not expert, and it's based on personal knowledge, personal perception. Here, the expert doesn't need personal perception. They don't need to have seen the accident. They could take the evidence from the accident, analyze it using their expertise, and then what is helpful to the jury now is they help teach the jury and educate them in the science or the underlying area of expertise, and then help them analyze the facts to better determine what happened as a factual matter. Okay, so the whole idea now is we have to see, do we have an actual witness who is very learned, or is this person kind of crazy, a quack, they're engaging in junk science? And so that's what we try to think about. Also, don't be elitist about this. You can have, you've probably heard stories of former college roommates where maybe they're experts in a certain recreational activity, let's say creating bongs and knowing how to smoke bongs or roll joints or engage in whatever kind of drug paraphernalia there is. They don't have a science degree in that per se, but based on their experience, they might be an expert in that area. So don't be elitist about this. It doesn't necessarily need to be scientific, learned areas of expertise. The Kumho Tire, which is a famous Supreme Court case, makes that point. All right, with experts, what do we generally want to prove with experts or show? First, Rule 702. 701 is the lay opinion, 702 is now the expert. That is the key rule, although 703 to 706 also deal with experts. But the key rule is 702, governing the admissibility of expert testimony. There are three threshold questions regarding admissibility of this kind of evidence. And so, this is why a lot of the law surrounding experts has grown up out of this. Number one, they have to be qualified. Is the witness really an expert in this area? And that's where you would lay out all of their degrees, if it's science, or their experience, or their specialized technical knowledge, whatever it may be, because they have to be qualified. Now, this is kind of like Rule 601 competency, where you have to make sure that the qualifications are met, the qualifications to be an expert witness. So oftentimes they'll ask the expert witness questions, and it's called voir direing the witness. Before the witness, the expert witness is qualified as an expert witness, and then you can ask about her opinion. There's a cross-examination that comes in the middle of the direct examination, and that's why it's called voir dire the expert witness, where you can question or cross-examine their qualifications. And if there is a concern as to the qualifications, we might want to get the judge to decide right then whether or not this person is competent to testify as an expert. Because if they are not, we don't want them to go ahead and give their expert and take their expert opinion, take all that time, unfairly influence the jury, and then on cross-examination find out that they aren't even qualified to be an expert, and then we have to tell the jury to disregard everything that they said regarding their expert opinion because they weren't really qualified as experts. So that's number one, making sure that you have the qualifications. Often in the voir dire, there will be times where the opposing attorney will say, no, I don't need to question them. In fact, I'll even stipulate, you don't even need to question them, I'll stipulate that they're an expert. Some attorneys will take the stipulation to save time. Others, though, want the jury to know all of the qualifications, not from an admissibility point of view, but from a weight point of view. Weight being that it gives the expert more credibility if you can lay out all of their qualifications. All right, so that's the first question. The second question is, even though they may be a qualified expert in a certain area, is that certain area in which they are an expert a proper subject matter of expertise? In other words, is it valid, legitimate science or technical knowledge or experience or something that really will help the jury? So is it a valid area of expertise or not? So even though they may be qualified in a certain area, that's a different question than if the subject matter area itself is valid. Question number one focuses on the person. Question number two focuses on the underlying science or the subject matter. And then this third area, and this is where a lot of the cross-examination, or if you're going to attack an expert, where it really goes to, and that is, even if they are a qualified expert, question number one, and even if they are qualified in a valid, proper subject matter area, a proper area and valid area of expertise, are they doing the right methodology, the right testing? Are they mixing test tubes? Are they not cleaning test tubes? Are they not doing what regular qualified experts do as far as their double-blind studies? Or are they using a scientific method? All of that has to do with their methodology. So look for those three areas to attack an expert witness. Who they are, right? Are they really qualified? How knowledgeable are they? Do they have the degrees? Do they have the publications? Then, even if they are qualified, at what are they qualified? What is the area? Is it a valid area of expertise? Does it have a good deal of knowledge? Is it recognized as such? Or is it some quack, newfangled science that isn't recognized as science at all? So what is it? And then third is sort of the how. How are they doing the science at which they are an expert? Are they doing the studies in the right way? Is their analysis being done the correct way? Are they doing it the way experts in the field would do this? Are they making mistakes that they shouldn't be making? Are they making procedural mistakes? Are they letting samples be contaminated? That sort of thing. Okay. So, in both lay and expert opinion, again, it has to be helpful to the jury, and that's why this issue of Fry and Daubert, we have to look at what do we require. Now, it used to be under the Fry case, and these, Fry wasn't a U.S. Supreme Court case, but the rest of these cases are U.S. Supreme Court cases. Fry was a Second Circuit Court of Appeals, 1923, where it was the precursor to a lie detector test. It was just a blood pressure analysis, and they wanted to use that to show if somebody was lying, and it hadn't gained general acceptance in the field, and so that's when the general acceptance theory started, or the general acceptance requirement. Now, there were no rules of evidence before 1975. They were started in 1972, and they got promulgated and started being acted about 1975. But in 1923, they weren't there, so it was all common law. So they developed this. Then after 1975, they have the rules, one of which is Rule 702, dealing with experts and areas of expertise. But the rule never said anything about the general acceptance requirements. And under Fry, the requirement was we can't use this as a proper subject matter unless the experts in the field generally accept this. It has gained a general acceptance in the area or the field of expertise. And so that was the standard for many, many years. Then 702 came by, and then Daubert which was about 1993, came out and said, wait a minute, Rule 702 controls now, it supersedes any common law we have because we've codified all of this, and 702 doesn't say anything about the general acceptance standard. Plus, we don't like the general acceptance standard because it keeps out a lot of otherwise cutting-edge technology, the newest, latest, and greatest findings. We're always behind the curve because of this time lag. And it's giving too much power to the experts. It's like the judge isn't engaging in making sure that the jury has an expert, but they're just giving away. They're handing too much over to these areas of expertise. So Dauber came up with a new set of factors to take into account that allow us to get in good, valid expert science and keep out the junk science and all of the quacks. So Fry was the general acceptance standard that we had in there, but the problem, it deferred too much to the experts and it was slow on cutting edge technology. And so Dauber came along and it gives back a gatekeeping function to the judge because it says we shouldn't be deferring so much to the experts anyway. And here are the factors under Rule 702 that we should take into account. Now, one of the factors is the general acceptance test of Fry, but it's just one factor to be taken into account. There are other factors that are taken into account, and then after Dauber, 702 then codified these rules or these factors in Dauber. And now we have these general acceptance is one of them, but a potential rate of error, is there peer review and peer study, and those sort of things that are looked at as far as the standard. And that way it's a happy medium between making sure we don't keep out cutting edge technology, but we don't also just defer too much to the experts. And so there has to be some intellectual rigor in the way the judge looks at the science involved. So Rule 702, as amended, now incorporates the Dauber factors, and it controls in federal court. Fry is still the test in California and some other states, so you could look at that state law and see how it differs, but most states have followed Dauber. Another case, G.E. Joyner, kind of the high watermark of Dauber, but this was really emphasized another point, and that is the judge's gatekeeping function to not cede so much power over to the experts, but to make sure that the expert can intellectually convince the judge that this is sound science, or at least it's using logical scientific method stuff, so that the judge can allow it to be given to the jury. Now, the juries, they often get overly influenced by experts. That's why judges have to stand there as the gatekeeper, because it's very valuable what experts have to say, but we can't let them run roughshod over the jury and just let anything in. That's why the judge has to be the standard bearer. In G.E. Joyner, the judges decided that the scientists were focusing much too much on correlation rather than causation. And just because there's a high correlation rate doesn't mean that proves a causal nexus. And so even though these experts were trying to say that, the court said, no, you're just mistaking correlation for causation, and so we're not going to allow that. Kumho-Tyre was an extension of Dauber, and then it got incorporated into 702. But the idea is that it's not just novel scientific expertise that we're talking about. It also could be experience or technical or specialty areas. Like, for instance, I said you could be an expert in how bongs are created, or an expert in the Kubo tire case. This was a seasoned, grizzled truck driver who could read the tread wear on the big tires and see if there was a problem with how the tire was wearing. Maybe there was a problem with the tire or the frame of the truck because of the uneven wear. And the point was that that kind of expertise is allowed because it's not just scientist and academic learning that could be helpful to the jury, but also specialized knowledge or experience or technical or technological things that a typical juror won't know that still could be used. So again, don't be elitist about the experts. Okay, now we come to the issue of hearsay under the 800 rules. And there's a lot to the rule, but if you go through it in stages and have an analytical framework, it's easier to deal with. So the 800s deal with hearsay. Starting out with the definition, what is it? An out-of-court statement made by a declarant. So the declarant is the out-of-court person who is making the out-of-court statement, which is a hearsay statement. And then the proponent, the people in court, are taking that statement, which is related by a witness in court, and they're using that statement of the declarant to prove the truth of the matter asserted by the declarant. Now, hearsay is not personal knowledge in a sense, because the witness on the stand, that's the only person we can cross-examine. But the only thing you can cross-examine the person on the witness stand, if you're trying to prove the truth of the matter asserted by the declarant who made it in an out-of-court statement, the only personal knowledge that the witness is going to have is what they heard the declarant say. And that's all they can say. They don't know. It's not their personal knowledge. It's the personal knowledge of the declarant. Now, even though the witness, let's say the witness might also have witnessed the incident and have some personal knowledge, well, they can testify to their personal knowledge and be cross-examined about it. But once they try to say, and this other witness, this declarant, said something to me, and what they said was this, now it's not my personal knowledge, it's their personal knowledge. Our personal knowledges may coincide, the declarant and the witness, but it doesn't matter. If I'm trying to relate an out-of-court statement of the witness, of the declarant, and it's being used to prove the truth of the matter asserted by the declarant to the jury, then it is hearsay. Even though I could be cross-examined about my personal knowledge, I can only be cross-examined about how well I heard what the declarant said, or read what they wrote, or saw their assertive conduct that they meant as a communication, and I understood their communication. Okay, so that's their basic definition of hearsay. So again, our analytical framework is going to be that. We go first to the definition of hearsay. We're not talking about non-hearsay to find out by the rules yet, nor are we talking about any of the exceptions. All of that will come. We're just talking about the definition. An out-of-court statement made by the declarant, right? That could either be written, oral, they can say it, they can write it, or assertive conduct. They may not say or write anything, but for instance, if you nod yes, you don't say anything, but you nod yes, you're communicating yes. So that is still a statement, even though it's not oral or written. It's intended as a communication. It's conduct intended as a communication, and therefore it is a statement. So it's related in court by the witness. So the witness is relating that out-of-court hearsay statement made by the declarant. And then what purpose is it being used for? This is the other thing that you have to show that you have hearsay. Is it being used to prove the truth of the matter asserted by the declarant? So if the declarant said that the light was green, and I, as the witness, am relating what the declarant out of court said, and we're using that statement to try to prove to the jury that the light was indeed red or green, and we want the jury to believe the assertion by the declarant because the declarant asserted it, that is hearsay, because the jury can't see how the declarant who made the out-of-court statement, we can't see what their demeanor is, how they withhold under cross-examination, no follow-up question, they're not under oath, all of those kind of things. Only I, the witness, right now, here today in court, I'm subject to all of those things. But if you're using hearsay, it's in a sense the real witness is the declarant, only there's no safeguards regarding that witness out of court. There are safeguards regarding me, the witness in court. I'm under oath, subject to cross-examination, but not this declarant when the declarant made their statement. So that's the definition then, right? A statement is an oral or written assertion. Now focus on the word assertion, because that really gets at it. Whether it's written, oral, or by conduct, those are just the means by which it is put out there. Those are the means by which it's communicated. But the key is that it is an assertion. So because it's an assertion, you have to watch out for other things that are not assertions but may still be spoken or written. For example, if the declarant makes an out-of-court utterance, but that utterance is just asking a question, what time is it? They're not asserting anything. They're just asking a question. So that cannot be a statement. Even though it's a statement in the regular Webster definition of an utterance, right? They uttered it, or they could write that out. It's not an assertion because they're not putting forward anything. They're just asking the question, right? Or they can have conduct, because that's all you can either have assertive or non-assertive conduct. It's only assertive conduct intended as a communication that will be a statement. Non-assertive conduct is just a person who's living their life, going about their day, and we can always testify about that conduct because that conduct is not intended as an assertion that's being communicated by the conduct. So if somebody asks me, is it raining? And I go like this and nod my head yes, even though it's not written or oral, it's assertive conduct. The conduct of my head moving up and down is the conduct, but it's assertive because I'm intending it as a communication. Non-assertive conduct would be I'm just walking along and I'm not asserting anything by that. An example that I'll give later here is if it's raining outside. If somebody asks me, is it raining? And I nod yes, then that's assertive conduct. If nobody says anything to me, but they see me walking with an umbrella, is that conduct? Yes, I'm walking with an umbrella. But is it assertive conduct where I'm intending to communicate that it's raining? No, I'm just living my life, and I'm keeping the raindrops off of me, but I'm not trying to communicate to anybody that it's raining. Unless I'm walking along, and someone might say, is it raining? And then I look at them, and I point to the umbrella. Now, that conduct of pointing to the umbrella is a way I'm trying to communicate an assertion made to a person. Okay, so it's that, right? It can be an assertion, oral or written, but not everything that is oral or written is an assertion, like the question. Or it could be non-verbal conduct, but the key is if it's intended as a communication. So you could think of the conduct as a substitute for the words. That's why it has to be assertive conduct. It has to be conduct that is making an assertion. And again, the examples of nodding the head, pointing, sign language obviously is conduct, but you're trying to communicate. Waving, demonstrating, anything like that that is designed for someone to see and then understand that you mean something by that is assertive conduct. Not simply living your life. So this is the example I gave of you're walking along with the umbrella, just living your life. Someone could say, I can observe that behavior, right? But if that behavior is intended to communicate something, then it might be assertive conduct. But if it's not intended to communicate anything, then it's not assertive conduct, and it doesn't even fit the definition of hearsay. So, if used to prove the truth of what the declarant has asserted, so to use the example, Jim told me the light was green, and if we're using that statement to prove the light was in fact green, then that's hearsay. If we're only using it to say that Jim made the statement, and we'll see this when we get into the purpose, the third part of it, but if we're saying Jim offered to buy my car, now we're using that to prove the existence of a contract because that was an offer, and then we're going to show the acceptance and the consideration, and then we have a contract. In that sense, we're not using it to prove the truth of the matter asserted by Jim. We're just saying, did those legally operative words get uttered out of his mouth? Because once they were uttered, it didn't matter if they were true or not true. They were words of an offer, and therefore it was like a legal act, and it's not hearsay. And again, the reason is, if all we care about is whether the words were uttered and not the truth of those words, then we now can rely on the witness that observed the words being uttered. Because if all we care about is, were the words uttered, then we have a witness to say yes or no, we can cross-examine them as to the truth of whether they were uttered or not. We don't care if they're true or not. Now, if we have to use these as true, and we're using the declarant's statement to prove the truth of the matter asserted by the declarant, because the declarant stated it, and because the declarant is credible, then it's going to be hearsay. Because it's like this is the real witness, the declarant, but they're not in court to be cross-examined. So, think of 3 questions when you're dealing with hearsay, and it kind of goes along with the definition. And we'll see this represented in a couple of ways. I'm going to give you these 3 questions laid out, and then I'm going to also do it a little bit more graphically. But the first thing, and let's go with what we said, the first part of the question focuses on whether it's a hearsay statement. So, we have an out-of-court statement that is an assertion which was a communication made by the declarant. That is, with words or written or oral words. But remember, it has to be an assertion. It can't just be like a question. It has to be an assertion, right? And these assertions may be verbal or non-verbal. Verbal in the sense of written or oral, or non-verbal, non-words, if your conduct is a substitute for those words because you're trying to communicate an assertion. If you're trying to communicate an assertion, then we have a statement. If you're just living your life, then we just have observable behavior that can be testified to, which would be circumstantial evidence of something else going on. So, if it's just observed behavior, not intended as an assertion by the declarant, but the declarant is just living their life, then we can, the witness can say what they saw because it's not even hearsay, because it's not even a statement. It doesn't fit the definition of the first question. Now remember, it's the statement by the declarant that we're concerned about. And the declarant must be a person. So if you say the clock says 2 o'clock, that's not hearsay because the clock isn't a person that should be cross-examined. We're not worried about the clock lying because clocks don't fabricate. The person may be seeing the clock, now they can fabricate and lie. So if you say Jim said that the clock said it was 4 o'clock, then there's hearsay that Jim said it, but there's not hearsay in that the clock said anything because the clock is not a declarant. You have to be a human being to be a declarant. So a radar gun, a thermometer, anything like that, a calculator, certain machines, things that you can observe, they don't say that. And this also could be a dog, like a bloodhound. A bloodhound follows a certain scent. You don't say, well, the dog was saying that that was the defendant's scent, but that's an out-of-court statement of the dog. the dog has to be a human, well, the declarant has to be a human being, a dog isn't, so that's just all observed behavior. The second question is the easier one of these, or the easiest one of these three, and that is you just got to make sure that even though you have a statement by the declarant that's made out of court before, it's being related in court by a witness who's on the stand. And that person can be cross-examined on what they heard the declarant say and do, but that's all they can do. They can't get into the mind of the declarant, and they are not the declarant. They're just the witness, and so the most they can offer is just what the declarant said. Now, note that it's possible for the witness and the declarant to be the same person. If I say, yes, I was at the car accident, and what did you do? I saw the accident. What else did you do? Well, I told the police officer that the defendant ran the red light. If I just testify and say the defendant ran the red light, not hearsay. Why? Because I'm the witness. I'm just saying what I saw in the past, but I'm saying it right now here. I'm not relating any out-of-court statement. I'm relating what I saw, but the only statement is what I'm testifying to right now as the witness. I could be cross-examined on it. But if I say I told the police officers that the light was red, now I'm bringing in the declarant. Who's that declarant? Me. But it's not the me of today on the witness stand. It's the me of 5 months ago when I told the police officer something. Technically, and this is important, so watch it, the jury can assess my witness demeanor and my witness testimony. I can be cross-examined. But the me of 5 months ago is no longer in existence. The me of 5 months ago who made that statement doesn't have demeanor to share with the jury. And the me of 5 months ago can't be followed up and cross-examined. Only the me of today can. So, watch for the status of the people involved. Make sure you make a distinction between the witness and the declarant. Even though the witness and the declarant can be the same person, you still have to analyze it in their different status. The status as a witness or the status as a declarant. Okay, the third question. The purpose for which you're using the declarant's assertion, the declarant's statement. Are you using the assertion to prove the assertion? Or are you just trying to prove that the words were uttered and the truth of those words ultimately don't matter? It's immaterial. What matters is just that the words were uttered or written or the communicative conduct was done. And that's it. We'll do some examples of these. Like a verbal act. If there's an oral contract and you heard the oral contract being made, it's not hearsay because we're not using it to prove the truth of the matter asserted by them. We're using it to say, did they make an oral contract? So we can question the witness whether they actually saw this oral contract being made. So what they said isn't hearsay, it doesn't fit the definition. It is true, it's an out-of-court statement by declarants, and they're intending them as communications. So that qualifies from the hearsay part. But the way in which we're using it is not to prove the truth of the matter asserted by the declarants, only to show that they engaged in the verbal act of uttering or writing those words, and those words have independent legal significance or independent circumstantial evidence. And that's why we're trying to get at them. Another example, perjury. Let's say I am going to talk about how someone perjured themselves in court. So, am I trying to prove the truth of the matter asserted by the declarant who perjured themselves? No. In fact, if it were true, then there would be no perjury. So you see, it's not the truth of the matter asserted that I'm doing it, but did they utter those untrue words? And in that point, it does matter, but it matters that they're untrue, not that they're true. So we're obviously not trying to prove their truth, just that the untrue statements were made because that has legal significance. Other legal significance, at a sentencing hearing, a defendant started to threaten the judge with the death penalty, saying, you're going to give me the death penalty, I'm going to give you the death penalty. All right. Now, if that judge later went in and tried to use that against the person's second trial for making threats, they couldn't say it was hearsay, because they'd say, well, wait, we're not even using it to prove the truth of the matter asserted. We're just using it to say, did they utter these threatening words? And once you utter the threatening words, then that is the legal act, right? If I say, I'm going to, assassinate some political leader with a ray gun, it doesn't matter that that's not true, and I don't have a ray gun. I uttered the words of a threat, which are an independent, legal, significant threat. I could go to jail for that, and so that would be the issue. So is the threat made, not whether the threat was really true, right? Because we're not using it to prove the truth of the matter asserted. We're only using it to prove that the words were uttered, or they were written, or that the conduct was successfully communicated as an assertion. Another one, if it's used to prove notice, then it's not hearsay. For example, in this one, the declarant told the defendant that their sidewalk was slippery, and now the defendant is being sued because someone fell on the sidewalk. Now, we'd have to prove that the sidewalk was slippery some other way. We couldn't prove that it was slippery because the declarant said so. If we did, then that would be hearsay by definition. But if all we're trying to prove is that the defendant was on notice of a problem and still didn't do anything about it, and now we're trying to get punitive damages against them because they were on notice and they didn't do anything about it, now we can use that, because we're not using it for the truth of the matter asserted, we're just using it to show that they were on notice. Don't get confused. We will use other evidence to say that the ice was slippery, but we're not using this hearsay statement to prove the ice was slippery. We're using this only to show that the defendant was on notice that there was a problem. Finally, if used just to prove the state of mind of the listener or the state of mind of the declarant, then you're not really using it to prove the truth of the matter asserted by the declarant, but it could be, was the declarant crazy? If the declarant said that they were the reincarnated ghost of Prince recently died, and now that they're the reincarnated ghost of Prince, then we're not trying to prove that they're really the ghost, we're trying to prove that they're delusional. And so was the sentence uttered? Was it made? And the witness could say whether or not it was made, and then that's circumstantial evidence of what crazy stuff was going on in the mind of the declarant. Or if we're trying to show that some little girl was afraid of the declarant said, I hate you and I'm going to kill your mother. Okay, and we say, hey, this person said that he hated the little girl and was going to kill her mother. We may prove that he killed the mother with other witnesses. We may prove that he hated the little girl through other means. But we're only using the statement, I hate your mother and I'm going to kill her, to show why the little girl was so afraid and ran away. And if that's an important legal issue that we need to show, then the effect on the listener would be a reason to do that. But it also could be on the state of mind of the declarant. Okay, so those are the three questions. And what's helpful now is to look at the definition also in terms of what we're trying to demonstrate here. So let's put a face to all of this. Let's say this person here holding the document is our declarant. And that declarant is making an out-of-court statement which says the light was green for the plaintiff. Now, was it a written or oral assertion? Yes, it was not a question, was it? It was an oral assertion because he said it, but he could have written it, still communicated. Now, if it were not oral or written, was it somehow assertive conduct intended as a communication? Let's say someone else said, who is the one that ran the red light? and then the declarant is the one who pointed at the defendant or at the plaintiff, now they have communicated a hearsay statement that plaintiff was the one who ran the red light, even though they didn't say or write those words, they pointed. Now they sort of incorporate the question, but the question is not an assertion, right? Because the question is just a question. Who ran the red light? But as soon as the person in response to the question points to the plaintiff, now they're asserting who ran the red light, and that's a communication, and it was intended as a communication. Now if for somehow you could prove that the declarant never even heard the question and just coincidentally was stretching their arm and went like this and just stretched their arm and pointed, now you would say, well, that wasn't really hearsay because that wasn't a communication that they intended to show. So it would be admissible, although it would be irrelevant at that point, because if it had nothing to do and they were just stretching their arm, there would be no circumstantial evidentiary value to it. But if it's a statement, it's conduct that is intended as an assertion, it's intended as a communication so that the listener or viewer or hearer understands what the declarant is trying to communicate to them. Now, only express assertions are hearsay statements, not implied assertions. So, for example, if I call up to somebody's house and I say, I want to buy some drugs, okay, and then there's a wiretap on that, and then they play that, and then the defendant is up for drug dealing, but then they say, well, that's hearsay. Why is that hearsay? Because it's an out-of-court statement where the certain person says, I want to buy drugs. Well, what is the communication? What is the express communication? It's only that I want to buy drugs. Are we trying to prove that the person wanted to buy drugs? No, the implied assertion is that the defendant is a drug dealer, and that's why I'm calling them to try to buy drugs from them. Well, true, but that's not the express assertion. The express assertion is that I want to buy drugs. And we're not trying to prove that I want to buy drugs. We're trying to prove that by me calling and wanting to buy drugs, it's circumstantial evidence that they are drug dealers. And therefore, it can be used for that purpose. Now, it's very nuanced, because it seems like it's trying to prove the truth of the matter asserted, but we're really not trying to prove what the personal desires of the caller are. We're trying to prove that because the caller thinks that this is the number they called to get drugs, that's circumstantial evidence that this is a place where they sell drugs. All right, so we can't include implied assertions. If that were the case, then virtually every statement would always be hearsay, because you could say the implied assertion, the circumstantial evidence, is what it is. And so that used to be the common law, but now under the advisory committee notes, that's no longer the law. It's only express assertions. Note too that silence can be assertive conduct, kind of the idea that no action is an action. And if someone came up and said, you know, are you a child molester? And the person just doesn't deny it, where a reasonable person would deny such a horrible charge, you might be able to argue that the silence was sort of a tacit admission that they are a child molester, because anyone who is not a child molester would say no. Now that's for the jury to play with, and that's for the judge to say, yeah, is there enough there? But from the admissibility point of view, a judge could say that the silence can sometimes be used to communicate an assertion. And if so, then it would qualify as an out-of-court hearsay statement. All right, notice, that's sort of that first question, right? Is this a statement? The second one is the declarant's assertion being related in court by a witness? So the out-of-court statement related in court by a witness who heard, read, or saw the assertive conduct being done. Now, notice that Implicit in this is that the declarant has to be a human being, and then the witness is also relating what that human being declarant is saying. And now the witness is telling the jury what the declarant said. All right, so he, the declarant, said the light was green for the plaintiff. So now we get to the purpose. The witness is telling the jury what the declarant said. And so the point is, it's going to be hearsay if we are trying to prove that the light was green for plaintiff because the declarant is asserting that the light was green for plaintiff. Notice what's going on here. The jury, right, although they're listening to the witness testify, the real witness is not the witness. The real witness is the declarant, because we're asking you to believe the declarant. But notice who's in court. The only person in court is that witness. That's the only person that they can test their credibility and cross-examine them and everything. They can't get through to the declarant. They can't see their testimony. That declarant's not under oath, all of those problems. So that's going to be hearsay if we're using it for that purpose, right? Notice the declarant is not under oath like the witness is. There's no cross-examination of that declarant like there is of the witness. There's no demeanor. They can't even see that declarant make the statements and judge whether they are shifty or they're nervous or their eyes are darting back and forth or they're sweating or whatever it may be, their voice is crackling, why they may not believe them. Now, if it's being used for some other purpose, in fact for any other purpose other than for the truth of the matter asserted by the declarant, then it is not hearsay because it doesn't satisfy the definition of hearsay. So even though it's an out-of-court statement, it's an assertion or it's assertive conduct, it's made by a declarant, the declarant is a human being, they're trying to communicate something, it's related by a human being witness, and the witness is relating it, but they're not asking the jury to believe the declarant as the real witness. In fact, what they're saying is, no, the buck stops with me. You believe me, the witness. You cross-examine me. You look at my demeanor. I'm the one under oath. You believe me, because if you believe me, all you have to believe is that the declarant uttered the words. And if the only thing that is important is that those words were uttered, not the truth of those words, but whether those words came out of his mouth, or his hand if he wrote it, or his actions if it were assertive conduct, then it doesn't fit the definition of hearsay because we don't have all the problems, and you're not believing the declarant because you're assessing the declarant's credibility. You're only assessing the credibility of the witness, because all that is important is if the witness heard or saw or read the declarant make that statement. So again, if the declarant threatened them, it doesn't matter if it's true or not, it's just, did those threats come out of their mouth? Or did the offer for a contract come out of their mouth? Or, whatever the example, the circumstantial evidence. Is the person crazy? Did it put fear in the mind of the person who heard him? That would be all that the jury is being asked to do, and that's okay, and we're focused on the purpose. So make sure you look at, the keys to this are making sure we have an out-of-court hearsay statement, and if so, what purpose is it being used for? And if it's being used to prove the truth of the matter asserted by the declarant, then it's hearsay. If not, then it's not going to be hearsay. And remember our concerns, again, for the out-of-court statement. It's an assertion, written or oral, or it's assertive conduct. It doesn't have to be verbal, written or oral, but it's a communication nonetheless. Now, if it's non-assertive, then it won't fit the statement, because all the declarant is doing is living their life. They're not meaning to communicate anything by that. So we have to make sure it's an intended communication. Express assertions are the only thing we're worried about, not implied assumptions. Implied assumptions, that's okay. That's circumstantial evidence, that's allowable. We're only using it for the truth of the matter asserted by the declarant if it's an express assertion. Now, watch out for this last one where hyperbole, you might think, well, no, isn't that an implied assertion? What if somebody said, I'm so hungry I can eat a horse? What they're really saying is, I'm very, very hungry. So that's what we go with. We're not, you could say to yourself, hey, we're not really trying to prove that the person can eat 1,000 pounds of meat right now. But that's not really what they're communicating. You can think of hyperbole as like a foreign language, and you could say, if I'm using Spanish to communicate something, then, and your definition is it has to be English, you could think of hyperbole as just a different language, and so we got to get at the true meaning. And hyperbole is just like a different language to express what the true meaning is. Whereas an implied assumption is more circumstantial evidence of something else that's going on. So make a distinction between express assertions, which are really just assumptions that are circumstantial evidence. So one of the examples we did, someone called another person Lefty, and we're trying to prove that his nickname is Lefty. Well, we can use the fact that somebody called him Lefty as an assertion, or I'm sorry, as circumstantial evidence that his name is Lefty, because the person didn't say, hey, your name is Lefty, right? Because then that would be the express assertion, because we would be believing the truth of the matter asserted by the declarant. But if they just say your name is Lefty, or if they just say, hey, Lefty, we can use that as circumstantial evidence, and because the assumption is what their name is, but it's an implied assertion, and therefore it wouldn't be hearsay. That's different than saying, some hyperbolic thing like the so hungry they can eat a horse. Okay, now that's the definition of hearsay. After we're done with the definition of hearsay, we then have to go to the issue of non-hearsay. So even if it fits the definition of hearsay, check to see if it's non-hearsay. Well, what is non-hearsay? There are two types of possible non-hearsay. 801D1, prior statements, and that's when the declarant is also the witness, testifying as to what they said before, that example that I gave you, that I'm the witness. But if I said something 3 weeks before, then there's my status as a declarant witness, or my status as a witness declarant. I could be the same person, but I have a different master status. So those prior statements are often, they can come in sometimes and not be defined as hearsay, even though they technically fit the definition of hearsay, and we're using it for the truth of the matter asserted. And then 801D2, statement of a party opponent. This are sometimes called party admissions, admission of a party opponent. And so if one of the parties to the lawsuit is also the declarant, then anything out of that declarant's mouth can be used against them because they're a party. So just by definition, anything that one of the parties says is not hearsay, and it can be used against them. But remember, it has to be used against you by your opponent. So if I want to use a self-serving statement that I made in the past, I couldn't do that because it's not statement of a party, it's statement of a party opponent, which means the other side has to use it against you. So this is no friendly thing for a party. This is if I want to use my opponent's statements against him, or if my opponent wants to use my statements against me. There are 3 types of prior statements and 5 types of party admissions, or statement of a party opponent. Okay, so let's look at the 801D1 prior statements. For this, under the rule, the declarant is also the witness. So I'm the witness, but I say something earlier as a declarant. And we're offering what they said in the past to prove the truth of the matter asserted. Right? So that prior statement by the declarant then might be used as long as I'm subject to cross-examination right now. So if I'm not subject to cross-examination, I don't testify, then they can't use my prior statement because I'm not subject to cross-examination. But if I'm on the stand, I testify, I'm subject to cross-examination, then maybe my prior statements can come in as non-hearsay or not hearsay by definition under one of the three. 801D1, if the prior statement is inconsistent with declarant's testimony and it was given under oath at a trial, hearing, deposition, or other proceeding, then it can come in not only to impeach under Rule 613, but also for the truth of the matter asserted. 801D1B, if it's a prior consistent statement. So if it's a statement that was made before, only it's different from what I am saying, or it's the same of what I'm saying now, then that usually would be inadmissible, but it can be admissible, and no oath is required, so it's not the requirements under A, but it can only be brought in if I'm trying to rebut a charge of recent fabrication. So the example would be this. I'm on the stand today, I say the light was green for the dean of the law school, okay? So someone accuses me and they say, hey, you're just trying to be friendly to the dean of the law school, or you want to make sure that the dean hires you again, or doesn't fire you, or gives you more money, or whatever it is. So you're doing that, or maybe the dean fired you, or I'm sorry, the dean bribed you and is saying, hey Fred, say that the light was green for me and I'll give you this $500. Okay, if that allegedly happened a year ago where the dean bribed me to say that the light was green for him, if I made a statement to the police 2 years ago, right, predating when the dean allegedly bribed me, I could use that to rebut the charge that I got bribed by the dean. Because why would the dean bribe me for $500 to say that the light was green for him if a year earlier I already told police that the light was green for him? Then and only then can you use a prior consistent statement, because the idea is that I am using the prior consistent statement to rebut the recent fabrication or the improper motive to lie. Now notice, if we didn't have a rule like this, whenever I would get questioned, my attorney would say, now Fred, was the light green for the dean? Yes. Have you always said this? Yes. In fact, 3 weeks ago, what was your testimony? That the light was green for the plaintiff, the dean? Yes. And a year before that the light was green for the dean. And 16 months before that, and 18 months before that, and go on. And then, hasn't your story always been the same, right? We would have all this unnecessary, additional, superfluous testimony. So no, you can't use your own prior consistent statements to try to bolster yourself, although if somebody attacks you for changing your story, and there's a prior consistent statement that predates that attack, then we allow you to use it under 801D1B. Then 801D1C, a prior identification. Notice, it doesn't matter if it's consistent or inconsistent. If you identify a person, then that prior ID can always come in, regardless of whether you're identifying them now consistently or you're not identifying them. It's inconsistent. It doesn't matter. We allow the prior identification to come in. No oath, no nothing, no recent fabrication. It doesn't have any of the requirements. And importantly, these could be used substantively. That means they could be used to prove the truth of the matter asserted in the prior statement. And that's okay, even though that satisfies the definition of hearsay, what we give with one hand, the definition of hearsay, we take with another, the definition of non-hearsay, because we're defining it out under the rule. So 801 A, B, and C were all about the definition of hearsay. Now 801 D, 1 and D2 are about non-hearsay under the rule, where we're going to say prior statements, not hearsay or non-hearsay, and statement of party opponent, not hearsay. All right, so it can be used substantively to prove the truth of the matter asserted. So what you're saying on the stand now as a witness, you might be able to use what you said before as a declarant if it meets A, B, or C, right? If it's a prior inconsistent statement and it was made under oath at a trial, hearing, deposition, or proceeding. And note, to be inconsistent, it doesn't have to be diametrically opposed 100%. It could be somewhat inconsistent. Like if I say Jim went to the store, and then later I say Jim and I went to the store. Now that's inconsistent because it's not exactly the same, although there are elements of it being consistent. Because in both instances, Jim went to the store. So there is the ability to argue at the level of categorization whether it's a consistent or mostly consistent or mostly inconsistent statement. And if you can get the judge to say it's either mostly consistent or mostly inconsistent, then you have the requirements of either A or B that would apply. But if you could say that it's mostly inconsistent and it was said under oath at a trial, deposition, hearing, or other proceeding like a grand jury indictment, then it could come in, not only to impeach, but to be used for the truth of the matter asserted. If it's a prior consistent or mostly consistent, again, don't apply A. No oath is required, no at a trial, hearing, deposition, or other proceeding, but what is required is a charge of recent fabrication or a motive to lie, or some kind of improper action that would get you to lie, where you can show that your statement has been consistent and it predated that motive to lie. And then C, if you identify someone from before a photo lineup, let's say, or a regular lineup, or just you saw them and you say, that's the person that I saw sitting in the police car, whatever it may be, that can come in. All right, so that's one level. The other one is 801 D2A. Even though it fits the definition of hearsay, it is defined out as non-hearsay, and that is a statement of a party opponent. Now there are 5 kinds. So 801 D2A, the first kind, would be a statement made from the party, the plaintiff or the defendant, and they state something. It doesn't matter if it's true, it doesn't matter if they have knowledge of it. If they say, the moon is made of blue cheese, then that statement is theirs and it can come in against them for whatever purpose. Even if we're trying to prove that the moon is made of blue cheese. Maybe the jury doesn't buy that, but if they wanted to, they can believe the truth of the matter stated by this declarant because it's a party, and the other side is using it against them. So if the defendant wants to show that the plaintiff said that the moon is made of blue cheese, they could do that, right? Even if they're trying to prove the truth of the matter asserted. Now, they may be trying to show that they're crazy, so it wouldn't even be hearsay to begin with. But if they're saying they're trying to use it for the truth of the matter asserted, then it could come in, and it could come in because it's right from the party. Notice how these overlap too. I mean, it may be that it is a prior inconsistent statement made under oath at a proceeding, hearing, deposition, or trial, and it was made by a party, so it's a statement of a party opponent. If it's both of those, make sure you say both of them. Don't just say one. Okay, the other one, 801 D2B, the statement in which the party manifests an adoption or belief. All right, so if somebody says, it's raining outside, isn't it? And I nod yes, now their statement has become mine, and it's my assertion, and that's what makes it hearsay. But if I'm the party that's nodding my head yes, now that non-party who said it's raining, their statement becomes my statement because I manifested a belief in that statement or I adopted it as my own. It doesn't matter if I have personal knowledge or not. That statement is now mine. Think of it this way. Think of it kind of like a gaming theory. If you say it or adopt it, it's your statement and you have to deal with it, and that's the way it is in a lawsuit. Your opponent can use everything you say against you. It's like the Miranda warnings. Anything you say can be used against you. Well, that's what happens with statement of party opponent, both if it's out of your mouth or your hand or your conduct, or if you adopt someone else's statement as your own, or there's a statement but you adopt a belief as your own, then it becomes your statement. Now we have ones where people stand in the shoes of someone else. The 801D2C statement by a person authorized to make a statement by a party. So if I hire a spokesperson or the CEO of a corporation makes a public announcement, they have the authority to speak on behalf of the organization, the corporation, or on behalf of me. Now, it only goes as far as their authorization goes, but to the extent they're my authorized spokesperson, what they say is as though I said it. So if my opponent wants to use something that my spokesperson says, they can use it. And even though my spokesperson isn't the party, I am, and my spokesperson's statement is mine under 801D2C. 801D2D is the statement of a party's agent. So let's say I have a company and I deliver computers, and I have a truck driver who delivers the computers for me, and he gets into an accident and says, oh, I'm drunk, I shouldn't have been driving. And then they sue me, respondeat superior, and I say to myself, hey, that truck driver was not authorized to make statements of negligence or anything else on me. I didn't hire that truck driver as my spokesperson. I just hired him to drive a truck, and he didn't do that good of a job either at it. So that's unfair. Too bad. He was my agent, he was in my employee, and the statement he made was made during the course of the employment relationship, and it was within the scope of the employment relationship. Now, if he said something else that didn't have, or he did something else and said something else that had absolutely nothing to do with me, then it can't be attributed to me if it wasn't within the scope of his employment and at the time of that employment relationship. And then the final one is 801D2E, statement of a co-conspirator. And this one would be if you have any kind of conspiracy, let's say a drug conspiracy, and that's what these were for, then any co-conspirator, anything that any co-conspirator says can be used against any other co-conspirator. All you have to do is show that the party and the co-conspirator were both part of the same conspiracy, and that the co-conspirator made a statement that was in furtherance of the conspiracy, and it was made during the course of the conspiracy. And if that's the case, then you have you've satisfied 801D2E. So watch out for things like statements that are made by a co-conspirator, but they're not really in furtherance of the conspiracy. If they say something like, I'm going to steal a car and we'll use that as the getaway car in the bank robbery, well, now that's a statement made in furtherance of the conspiracy. But if it's someone that says, hey, do you want some Coke? I'm going to go out and get some coffee and some Coca-Cola, not cocaine. I'm going to go out and get some Coca-Cola and some coffee. I'll get some for you too. Then that's not really in furtherance of the conspiracy, unless you can say, well, they were very tired, they were thirsty, they were casing a joint and getting some refreshments to keep them up while they cased the joint. That was in furtherance of the conspiracy. But if not, if you're just over each other's house watching a game or something, then it's not in furtherance. So you have to look at the context in which the statement was made. Now, for all of these, 5, be thinking. This is why you always do this. Ask yourself, who is the declarant? And if the declarant is a party, then also ask, is the other party trying to use this statement? If the party is trying to use their own statement, it's no good. Don't fall for that trick. It's only if the opponent is trying to use it. So again, 801D2A statement out of the party's own mouth. It's sort of open season on whatever they say. You can use it against them. 801D2B, where they manifest an adoption or belief in the truth of the statement, silence, anything, whatever the party adopts, that can be used against them. It's as though they made it, the statement themselves. And then these other ones, 3, 4, and 5, right? 801D2, C, D, and E, another person is kind of standing in the shoes of the party opponent. A spokesperson who's authorized to speak on their behalf, an agent who is working for them and they say something that is being used against them and it's made during the course of that relationship and in the scope of that employment relationship, or 801D2E, the statement of a co-conspirator, if that co-conspirator and the party opponent are part of a conspiracy and the statement is made in furtherance of the conspiracy during the course of the conspiracy. Remember, you don't have to demonstrate that they're charged for conspiracy. You just have to show that there's a conspiracy. And with respect to these three, 801D2C, D, and E, where either an agent, authorized spokesperson, or co-conspirator is standing in your shoes, in order to show the authorization of the spokesperson, or to show the agency of the worker, or to show the co-conspirator status, you have to have some corroborating evidence. It can't just be the hearsay statement itself. That was the Bourgeois case and the bootstrapping. You can't do any pure bootstrapping. In other words, you have to have other evidence that shows the existence of the conspiracy, the authorization, or the agency. The hearsay statement can be a part of it. It just can't be the sole part of it. So there has to be corroborating evidence, and then that will be fine. Okay, we're going to stop, take a little bit of a break now, so we'll edit this out, but I'm going to come back and do hearsay exceptions. Okay, let's continue. Now with the exceptions to the hearsay rule. So even if it is defined as hearsay, it meets the definition, and let's say that you looked at the non-hearsay exclusions under 801D 1 and 2, and none of those 8 applied, still see if there is an exception under 803 or 804. All right? So, in certain circumstances, hearsay is trustworthy, so we make many, many exceptions. And under the 803 rules, there are 23 exceptions, and under the 804 rules, there are about 5 exceptions that we have. So, exceptions and non-hearsay, by definition, almost swallow up the rule. A lot of hearsay can come in because of the exclusions and the exceptions, but you have to know how to argue it and which ones are there. But don't forget that sometimes you can get the information in because it doesn't fit the definition of hearsay, and then it's admissible for that purpose. All right, the exceptions. Now again, not a question of the definition of hearsay, right? At a court statement made for the truth of the matter asserted by the declarant, and it's not a question of fitting within the definition, right? Because it's defined out as non-hearsay under 801 D1 or D2. Those are the first two things that we had been through. Now we're saying it's hearsay by definition, it's not defined out, but now we're looking for one of the exceptions to apply. Let's go to the 804 exceptions first. And remember, with 804 exceptions, the declarant has to be unavailable. The 803 exceptions, it doesn't matter where the declarant is. So don't worry about that. But for the 804B exceptions, the declarant has to be unavailable. And the way you define unavailability is to go to Rule 804A. And in there, you can see that it's a declarant is unavailable, if they're absent, if they're physically not there, or they're dead. But it's not just that. If they're exercising a privilege and they can't be there, or they're there physically, but they're taking the Fifth Amendment or spousal privilege or some other kind of privilege, then they are not available to testify. If they are sick or infirm, or they have absolutely no memory, or something like that. So look at the 804 availability or unavailability determinations and make sure that your declarant is not there. And this shows that the 804 exceptions are sometimes thought as a little bit weaker exceptions. The reason being that if the declarant is available, then forget it. We're not going to use these exceptions. We want to hear straight from the horse's mouth from the declarant. But if the declarant is not available, well, then this is the second best thing. We'll go ahead and allow these exceptions. Where with the 803 exceptions, it doesn't matter if they're available or not. So sometimes they'll say the 803 exceptions are more trustworthy, more reliable, they're stronger, but the 804 exceptions are a little bit weaker. That's why they're not acceptable unless the declarant is unavailable. So always ask who the declarant is to see if statement of a party opponent applies, but also ask, is the declarant available? And if so, you cannot use the 804B exceptions. But if not available under Rule 804A, then you could use these exceptions. Okay, so for these 804B exceptions, assuming that the declarant is unavailable, we can look at the first one, former testimony, 804B1, right? Now, you might say to yourself, well, wait, former testimony, why doesn't this exception qualify as an 801D, 1A, or B prior statements which are non-hearsay? And remember, it's because of what we said about the availability. A witness is not also the declarant who is now subject to cross-examination. So usually when we're dealing with prior statements, you're going to have an individual that has to be available for cross-examination, right? But if they're available for cross-examination, then the declarant is available, and so you can't use former testimony. So make sure that when you're thinking of using, a number of different exceptions or exclusions, you can do that, but you can't define them in a way that is logically impossible. In other words, they can't be available for cross-examination and simultaneously be unavailable for cross-examination. They got to be one or the other. Okay, so why are they not subject to cross-examination? Because they have to be unavailable since it's an 804 exception. All right, now with the former testimony, just a couple of things with respect to that. Number one, the confrontation clause knocks that out in criminal cases usually, because remember with the confrontation clause under Crawford and Davis, if the declarant's statement, hearsay statement, is testimonial in nature, then it's inadmissible, not because there isn't a hearsay exception for it, but because the Sixth Amendment Confrontation Clause, which says that you can confront your witnesses against you at trial, that is violated. And so even though there may be an exception here, it would work. And former testimony is going to be testimonial in nature. But that's in a criminal case, not in a civil case. Sixth Amendment only applies in a civil or a criminal case. So former testimony is available in a civil case. All right? And make sure, too, with former testimony, that the person against whom you're using it was a person who had the opportunity and the motive to question the declarant's former testimony or develop that former testimony. If they didn't have the same motive and opportunity, then it would be unfair to use it against them. It's kind of like collateral estoppel, issue preclusion, where you can only use it against a party who had the opportunity to litigate. It would be unfair if you use it against someone who didn't have the opportunity to develop the testimony. Remember also in civil cases, it's either the party had the opportunity to develop the testimony, the motivation and the opportunity to develop the testimony, or their predecessor in interest, which could be like the business that they, the company from which they bought the business. If it was company A and they sold company A to company B, and now former testimony that was used against company A is now trying to be used against company B, you might say to yourself, well, company B wasn't in the first trial, that was company A. But if company A was the predecessor in interest of company B, then you could use that former testimony against company A, now against company B, because it's like company B was standing in the shoes of company A, and so it would be fair. All right, that's former testimony. 804B2, dying declaration. This is if somebody, as they are dying, or they think that their death is imminent, and if they think their death is imminent, then the idea is that they're not going to lie, probably about something right before they're going to die, because they believe it's true, and so we'll allow a dying declaration to come in. Now, again, the idea is that you're thinking they're not going to lie. Now, the other testimonial capacities may be hurting right then, right? Your perception, your memory, all of those things. That's not really what we're concerned about with hearsay, though. With hearsay, we're concerned that the declarant may lie and may not have any incentive not to lie because they're not under oath and that sort of thing. So here we have to find the trustworthiness. And if the person makes a statement under the fear of their imminent death, and it's about the cause or circumstances of their death, then it can be used against them. So if somebody said, oh, I'm about to die and I cheated on my taxes, that wouldn't be allowed because it doesn't have to deal with it, the cause and circumstances of their death. But if this person, like in my example here, I'm a goner, my mother killed me, well, that statement has to do with the cause or circumstances of the death. Now, if that person does not ultimately die, it doesn't matter. They believed that they were going to die. And so that is what would cause them not to lie, because they wouldn't have anything to lose. Statement against interest, 804B3. And again, you've got to make sure that the declarant is unavailable. So let's say this time the declarant says, I cheated the IRS out of $2,000. Well, the rationale would be that a reasonable declarant would not lie about something that would harm his own legal or economic interest unless he truly believed it was a fact. And thus that gives us the reliability. You wouldn't put yourself in harm's way that way. So again, it's okay to show that they're probably not going to lie to make themselves look bad. But again, the other testimonial capacities, you can't really test about perception, memory, or clarity, but so what? Usually someone will not make this kind of statement which hurts themselves unless it's truly against their interest. Okay, so 804B4, family pedigree, that's just pretty straightforward. Just read the rule. It's often not used that much. 804B5 was used for the residual exception, which is now Rule 807, which we will talk about. The one on here that I don't have is 804B6, and that is forfeiture by wrongdoing. That is where if the declarant is unavailable because one of the parties killed them or bribed them or threatened them or somehow procured their unavailability, the party who procured a witness's unavailability should not be able to take advantage of the hearsay rule and be rewarded for making sure that that witness doesn't show up. Okay, so I'm a defendant, I'm been charged with bank robbery. There's a witness there who saw that I committed the bank robbery, and they made a statement to the police that I committed the bank robbery. So I say to that person, hey, if you know what's good for you, you won't show up to trial. If you do, your family might get hurt. So guess what? They don't show up to trial. They don't show up to trial, that's the star witness. The prosecution then wants to say, well, let's get the statement to the police officer that Fred was the bank robber. And then what I say is, no, hearsay. You can't use that because it's hearsay. 804b6 would say, I shouldn't be able to use their unavailability to my advantage that way where I am rewarded for procuring their absence. Now, interestingly, in my example, I also would, you could also make the argument that it would fit with one of the exclusions, and that exclusion would be 801D1C, a prior identification. Remember, so they could use it that way, and it would come in. But anyway, the idea is the same. If you procure someone's absence, you can't take advantage of the fact that they don't show up and then claim hearsay. So the hearsay exception is, we are not going to allow wrongdoers to hide behind their wrongdoing and get the advantage of the protection of the hearsay rule when the only reason it's hearsay is because you procured their unavailability. Okay, now for the 803 exceptions. These are the stronger ones because 803, it doesn't matter if the declarant is available or unavailable. So 803.1, present sense impression. If the declarant describes an event that they perceived and it prompts them to give a kind of a play-by-play description, then it will fit the present sense impression. Notice the timing. The description, the play-by-play description has to be substantially contemporaneous as the event is occurring. The idea there is that you don't have time to fabricate or lie, and therefore it's going to be reliable, and therefore that's why it's an exception to the hearsay rule. So anyone that is describing something that they see around them contemporaneously with it going on is that's going to fit the exception because they're not likely to fabricate that issue. Similar, related, different in a few respects, but often overlapping, is the 803.2 excited utterance. What does the excited utterance mean? All that is that if the declarant makes a statement that relates to a startling event, and on an exam, bar exam, whatever, look for exclamation points because the testers would have to demonstrate that it's a startling, exciting event, right? And then you make a statement that relates to that startling event. Then it will be admissible. Now notice the timing. The timing requirement is not the same as with present sense impression. Present sense impression, present is even in the title, where the timing requirement is substantially contemporaneous. Excited utterance, it's only an implicit timing requirement. And it doesn't even have anything to do with the time, really. It's just how long is the declarant under the stress of an event. Now, usually when the event happens, the declarant is under the stress, and as time goes on, the stress dissipates. And so after a while, once the stress dissipates, then it's no longer an excited utterance. It's just an utterance. And so when you lose the excitement with time, then you lose it. So, or you can't use the exception. So there is a timing requirement, but it is implicit. Now, the declarant must have personal knowledge of the event, or at least think that they have personal knowledge of the event that is giving them the stress that they're under. And so they make the statement. Okay, that's excited utterance. 803.3, the then existing mental, emotional, or physical condition. Statement relates to the present then existing condition of the declarant. Now, notice, this sounds a lot like present sense impression, and it really is, because it still involves timing, right? But instead of saying present, they use the term then existing. Now, it's mental, emotional, or physical condition. If you think of present sense impression as the declarant looking outward and describing that which he sees or she sees and perceives as their impression, then that's 803.1 present sense impression. If instead of looking out there, the declarant looks and describes what's going on as it's going on, if you just put a big mirror in front of the declarant, and now the declarant sees herself, and in a sense metaphorically sees herself to say, what is my mental condition, my emotional condition, my physical condition, sort of looking inward with the present sense impression, then we would call it then existing mental, emotional, or physical condition. And then they can explain it that way. And this could be mental or physical. So if somebody gets a shot and it hurts, they say, hey, that hurts, that's my physical condition. But they can also give their then existing mental. I am afraid of needles. Or that's my emotional. I have this visceral fear of needles, and oh, it's bothering me. That's emotional. All of those would fit under then existing mental, emotional, or physical condition, as long as they say it as it's happening, substantially contemporaneous, like with 803.1. Now, that said, what about future intentions? Or I guess that's sort of redundant because your intentions are about the future. But what if they say, all right, this is your then existing state of mind. That usually says what I am presently thinking. Now, if you're presently thinking about a past event, you can't really talk about the past event with this one, but you can talk about your present feeling about a past event. That's okay, because it's your present feeling. However, if you're trying to prove the truth of the past event, then this doesn't work, because even though it's then existing, you're not talking about your then existing thing, you're talking about the truth of the past event, and so that's outside of the rule. So, for the past event, no, but what about future conduct? In a way, if we can't do the past, we can only do the present, it would seem like we can't talk about the future either. We can only talk about the present. But there is a real conceptual difference between the past and things that have already happened, and then the present, things which are transpiring, and then the future, things that have not yet transpired. So of course we can't talk about things that have yet transpired, but if we talk about an intention to do something in the future, the intention to do something in the future is really a present idea, because you're thinking about it right now. So if you think, all right, there's your brain or your mind, and we're looking at the timing involved here, and we're saying, I want to talk about a past event, or the way I was thinking about a past event. You cannot do that. That's the line, that red line there that says no. That would swallow up the entire hearsay rule. So you only get the present, right? So we have those distinctions. The easiest part is the present, because it says then existing mental, physical, or emotional state. So you get to talk about that. Now, a future conduct, even though conceptually that involves the future, that's really just an extension of the present, because you're presently thinking about things that will transpire. When you're planning, your plan is a present plan. Even though the plan is about the future, the plan is really existing now, in the here and now, so it's present. So intentions are admissible as then existing emotional, mental, or physical condition. Now the past, represented by the red there, that this exception does not cover, because if that were the case, then all things could come in under this exception. So that's no good, right, with respect to those acts. But with respect to these future intentions, they are circumstantial evidence of the declarant's acts. Now, there is a split of authority in, is it circumstantial evidence in what someone else did? So all jurisdictions will say, if, I'm Fred and I say, I plan to go to the state fair. Okay, everyone would say that we could use my then existing mental, emotional statement, right? That I plan to go to the state fair, even though that's hearsay, later on when we want to use it. When I was saying it, it was then existing. So that would qualify, and everyone would say that fits within the 8033 exception. If I say, Carl and I are going to meet at the state fair, some courts hold that that's circumstantial evidence that Carl and I actually did go to the state fair, right? Just like all courts hold that if I say I plan to go to the state fair, that hearsay statement would be usable as circumstantial evidence to show that I did go to the state fair. There's a split of authority, though, when it comes to I plan to meet Carl at the state fair. Some jurisdictions will say that's circumstantial evidence that both Fred and Carl met and went to the state fair. Other jurisdictions would say, no, even though Fred said Carl and I plan to go to the state fair, we can only use that as circumstantial evidence that Fred went, because the declarant can only talk about themselves. They can't talk about another person, and we can't hold it to that other person's intentions. And so that's the thinking there, where other ones are saying, well, it's just circumstantial evidence that they were there, and so we'll allow it to be used. So anyway, there's a split of authority on that one. All right? Now, remember, for 8033, it must relate to how the declarant is feeling at the time, not how he may have felt in the past. So it can be at the time, the present, and it can be about the future, which is really a present intention about the future. Now go to 8034, statement to receive treatment or diagnosis. In this example, the declarant, the reason it's reliable is the declarant is not going to lie when they're trying to get treatment or diagnosis for some physical illness or condition or something, right? So if if my arm is hurting and they think they may have to amputate my arm, I'm not going to tell them that it's my right arm when it's really my left arm, because I don't want them to amputate the wrong arm. Similarly, I don't want to get the wrong biotics. I don't want to lie and say I'm allergic to penicillin when I'm not, or I'm not allergic to penicillin when I am. Okay, but what I say has to be reasonably pertinent to the diagnosis. So if I'm trying to get a diagnosis as to why I hurt my foot, I could say, oh, I fell on a 6-inch step and I twisted my ankle. Okay, that's fine. If I say I slipped on a 6-inch step that was negligently marked as an 8-inch step, and therefore I was misled by the defendant who should be responsible for my damages to my foot, then it would be all right. Well, that we don't need. The doctor doesn't need to know all that legal mumbo jumbo trying to get the other side to be negligent to do your diagnosis. The doctor would only need. She would only need to say, all right, I just need to know that you fell. So it has to be reasonably pertinent. So go ahead and give me the penicillin. I'm not allergic. It is okay, but I sure felt bad yesterday. Now, the go ahead and give the penicillin, I am not allergic to do it. It's okay, right? I'm not allergic to penicillin, or it doesn't hurt. That could fit under 8033 or 8034. It's a little closer to 8034 because you're trying to get treatment or diagnosis, so it would fit more squarely there within, but it also conceivably could be 8033. But when they say, I sure felt bad yesterday, there's no way that can go to 8033 because that's not a then existing present, right? That's yesterday. However, it can go into 8034 because 8034 is you're stating this to receive treatment or diagnosis. The reliability is not that you're just describing something that's present and therefore you don't have a reason to lie. That's 8033. The reliability of 8034 is that I'm not going to lie, not because I don't have time to lie, but because I don't want to receive the wrong diagnosis. I have a self-interest in telling the truth here as to what is wrong. So it's okay if I tell them my stomach hurt yesterday because they're going to need to know that to figure out, is this poisoning, food poisoning? Is it some other kind of virus? Do I need penicillin? Not penicillin? It's not a bacterial thing? Whatever. So those are different. So again, 8033 is then existing, which is present only, where the statement to receive treatment or diagnosis could be past or present, because your symptoms can change. So you can either give your present symptoms, which both 8033 would work, and 8034, or your past symptoms, where only 8034 would work. 8035 is the 8035 is the past recollection recorded, and that is similar to 8036 in that what we want to do is make sure that for 8035, a person may have had knowledge about something that was accurate at the time, but they no longer have memory. If they do have memory that can be sparked, then you would just use Rule 612. But under 8035, if it's past recollection recorded, then what you would want to do is say, okay, if I had knowledge of this in the past, but I don't remember it now, but I had knowledge of it in the past, and I recorded it, then we could use what I had written down in the past. But it only could be read. It can't be given to the jury. So an example of this would be if I own a window washing business, or I'm sorry, if I am moving, and in moving I pack up some bags and boxes, and then I label what those boxes are. I may 6 months from now forget what those labels are in the boxes. I may forget what's in the boxes. I may have no independent knowledge. Even if you try to show me those, it won't spark my memory because I won't remember what little things I put into those boxes. But I could say, I don't have memory. It can't be refreshed under 612. But even though I don't have memory, I remember making a list. And at the time, I made the list. It was adopted by me. It was accurate. I had an incentive to make it accurate because I wanted to make sure I knew which boxes all my stuff was in and what was in each one of those boxes. And I wrote it down. And so I could read those lists, read it to the jury, and then that's past recollection recorded. So I remembered in the past, I don't remember now, but it was recorded, and it hits the hearsay exception under 8035. Okay, now to 8036 and the business records, which is very similar to past recollection recorded. In fact, 8036 was created after 8035, past recollection recorded, only they did it in the context of a business or a routine organization. And so they have this, that 8036 that deals with it specifically. So, record of the events were made at or near the time by a person with knowledge, usually an employee, but someone with responsibility to make this business record. The record is kept in the ordinary course of a regularly conducted business activity, and it was a regular practice of the business or the person to do this kind of thing, right? And the person who did it had a business duty to make the record. The person who did it also is qualified because they're the custodian of the documents, or they are charged with producing this business record. There's nothing in it to show that it's untrustworthy or it was made with an eye toward litigation, and therefore it can go forward. All right, now to go to the example I was thinking of, which is the window washing business. Let's say I have my window washers wash the windows and record which windows of which building get washed. And there's a business reason for doing that, to know that we don't miss any windows, and we make sure we do any windows, and if there's any problem or someone complains, we could go back and look at our windows and see, oh, did we miss that window or didn't we? Or if there's a complaint on the bill, we could show all the work we've done. All right, so for that window washing business, we could say the record of events was made at or near the time. So after they wash a window, they check off that window on the building by a person with knowledge. Yes, the window washer who did it. There's an employee who has the responsibility to do it. So there's a responsibility for them to mark off the windows that they wash. Is it a record kept in the ordinary course of a regularly conducted business activity? Yes, we're not doing this just for our health. We're taking time to make sure we have these records. And we do this all the time in case there's ever a problem. Was the regular practice of the business by a person with a business duty to make the record? Yes, part of their job is to make sure they mark off the windows that they wash. Is the witness now qualified? It's either that window washer who can attest to their own record, or a custodian of records who keeps all of the window washer's records in one place and therefore has them and is familiar with them. Now, here's the big one. Nothing to show it's untrustworthy, okay? Did we never keep records of which windows we washed, and then we got sued for fraud, for taking money for washing windows that we never washed? And then all of a sudden, we produce a bunch of records showing that we washed all the windows, and it's all retroactive, and they were created, and they go back, and they cover the last 3 years. Well, even though those are business records, those are not trustworthy given the context in which they were created, so they would probably be inadmissible. So, was the key, though, is the regular practice of the business by a person with a business duty to make the record. I have this case here too, Johnson v. Luss, police officer, investigation okay, but problem with witness with no business duty. This was a case where they were trying to get those some records, and the officers did an investigation, but the people who were doing the investigation didn't have a business duty, and so that's where a lot of these cases get thrown out, is the one that has a business duty to make the record is not the one who actually made the record, and therefore it may lead to some untrustworthy circumstances. Okay, 8037, absence of a business record. This is just like 8036, that if I wanted to show that certain windows didn't get done, and I pull the records and I show that one window washer didn't wash a whole side of a building and the check marks aren't there, then the absence of the check marks can also be assertions that the work was never done, and it wouldn't be hearsay under 8037. So absence of business records works as well. Then we have the 8038 public records exception. Same exact rationale as 8036 business records, and the same requirements are there, and even the trustworthiness requirement. So 8036 and 8038 have this additional trustworthiness requirement. All the other exceptions, the trustworthiness and reliability is already built in. But with 8036 and 8038, you've got to look for the additional part. All right, so it's the same rationale. A couple of things that are different. In a civil case, under 8036C, factual findings and opinions are allowed. What does that mean? That means that if there's an investigator that has a duty to investigate and make a public record, we're going to allow their opinions. This was the Bailey case, where it was an aircraft that went down, and they were trying to say, okay, the FAA, the Federal Aviation Administration, did an investigation, and the JAG officer did an investigation as to why the plane went down. And if it was pilot error, there would be no liability, but if it was due to a design defect, there would be. And so they let the JAG officer do an investigation and come to some conclusions. And they can even include their conclusions in these reports, and those get in and they're admissible. So you could use that. Also, under 803.6b, there is an exception where in a criminal case, you cannot use a police report as a public records exception if the police, or in lieu of the police officer not going to trial. So we don't want to convict people based on police reports. We want the police to actually be there. And so 803.8 doesn't allow police reports in lieu of police officers not being there. Okay, that's enough. Because the exceptions are set forth in the intro and overview, and there's little explanations of them in there, so I leave the rest of them. And they're all pretty straightforward, and they make sense. So I'll leave you to those for 803.9 through 23. Now, note that 805, hearsay within hearsay, sometimes called double or multiple hearsay. And if you have this, look for this, because it might be that there is a report, but in the report, someone is saying what someone else said. So there would be different levels of hearsay, 2 levels of hearsay. All it means is you need an argument or a justification for each hearsay along the way. So an example, our first declarant is Donna. Donna, who is the defendant, says, I stole the painting. So then Donna, declarant number 1, says that to declarant number 2, who is Sel. Sel believes he is innocent, but he gets arrested, and he's very upset that he is being wrongfully arrested. And he says to the police officer, hey, declarant number 1, Donna, told me, I'm declarant number 2, Sel, so Donna told me that she stole the painting. Now, there's going to be 2 levels of hearsay because the witness is the police officer. And the police officer is going to tell the jury, hey, Sel told me that Donna told him, right? Declarant number 2, Sel, told me that declarant number 1, Donna, told him that she, Donna, declarant number 1, stole the painting. Why are we here? To prove that Donna stole the painting, right? So we want you to believe the truth of the matter asserted by Donna that she stole the painting. Well, there are 2 levels of hearsay because there are 2 declarants there, right? The witness is the police officer, declarant number 2 is Sel, declarant number 1 is Donna. So we have to think of arguments as to each level. Now, Donna is charged with stealing the painting, so can we use her statement to Sel? And when you think about it, you'd say, wait, Donna is a defendant. We always ask who is the declarant. Why? Because if the declarant is a party, maybe we can use 801(d)(2)(a) statement of a party opponent. Is the prosecution, her party opponent, using it against Donna the party, the defendant? Yes. So it's not that it's self-serving, but it's being used by a party opponent. Therefore, it's non-hearsay under the exclusion. So far, so good. We've taken care of 1 level of the hearsay, and that's declarant number 1, Donna's statement to Sel. Hey, it's statement of a party opponent. But what about Sel's statement now to the police officer? Because that is hearsay too. Well, now when we give it away and we kind of push it a little bit here, but Sel was startled by his false arrest, by thinking, oh no, I'm going to have to take the rap for Donna, and I didn't even steal it. So he says, it wasn't me, it was Donna that stole it. And maybe we say he blurts it out and it becomes an excited utterance. So maybe there's an excited utterance there. Now, maybe I should have put a little exclamation point there to let you know that it was startled. And see, that's sort of unfair. And I wanted to make that point that look for the exclamation points because it's hard to show tone and raising of a voice and all of that in print unless you use all capital letters or exclamation points. So at this point, we have each level taken care of, right? Non-hearsay, 801D, within hearsay applies to the Rule 805 exception. So note that it says you have to find an exception for everyone, and technically 801D2A is not an exception, it's an exclusion, but the way it gets interpreted, non-hearsay exclusions are thought to just be exceptions for purposes of Rule 805. Find an exception or some explanation for each level of hearsay along the way. All right, so with that then, what do we have? We have our definition of hearsay. So 801A through C, we use all those case interpretations. It's an out-of-court statement, communication related by a witness in court, used to prove the truth of the matter asserted by the declarant. If it fits the hearsay rule, then it's hearsay. So what do you do next? Next, you check to see if it's not hearsay under 801D1 or 2. Is it one of the 3 prior statements, or is it one of the 5 statements of a party opponent? Right? So look at 801D1 or 801D2 to see if it is a statement of a party opponent. All right, so that's the first thing you do, right? And we've been looking at those, that non-hearsay. Then, what's the next thing? Does the statement even fit the definition of hearsay? So that's kind of what we're trying to do here, right? Is it an out-of-court statement related by the witness, intended to prove the truth of the matter asserted by the declarant, or are we merely saying that they uttered their words, asserted conduct, they're trying to prove something? That's the first thing. Do we have the definition of hearsay? Second, if it is hearsay, then ask if it's non-hearsay. Is it a prior statement under A, B, or C, a prior inconsistent statement, consistent statement, or prior ID? Inconsistent is under oath at a proceeding, trial, hearing, or deposition. Consistent if it rebuts a recent fabrication charge or motive to lie or improper motive, or C, if it's prior identification made after perceiving somebody. And is the declarant now subject to cross-examination? Always check that for these ones. Then B, is this a statement of a party opponent from the declarant themselves, because the declarant is the party opponent, or is it adopted by the party opponent? So what the declarant said is adopted. Is the person authorized? Are they an agent? Are they co-conspirator? So always ask who the declarant is, so you can see if they are a party opponent. Then, if it's hearsay and it's not non-hearsay, right, is there an exception under 803 making it admissible under the exceptions? So think, present sense impression, excited utterance, then existing mental or physical condition, statement or treatment for diagnosis, past recollection recorded, business records, absence of business records, or public records. Those first 8 are the most important ones. Then it goes 9 to 23. Just look in the intro and overview for those, but they're pretty self-explanatory. Next, if there's no 803 exception, look for the 804B exceptions where the declarant is unavailable. But remember, before you go to 804B, go to 804A to make sure the declarant is unavailable. Then, when we get that, just go former testimony, dying declaration, or forfeiture by wrongdoing. A statement against interest should also be in there, 804B3. Then there's the residual exception. The residual exception is even if it doesn't fit any of the exceptions, if it's close, is there yet another reason why the court should hear this? In other words, if you could come up with some other trustworthiness, then under the residual catch-all exception, you can use that. Don't forget about the Sixth Amendment. In criminal cases, there's a confrontation clause, but only if what the declarant says is testimonial in nature, right? So you have a right to confront witnesses against you at trial, to cross-examine them, and you can't do that if the true witness against you is the declarant, not the witness on the stand, and therefore you're not able to use that if it's testimonial in nature. If it's not testimonial in nature, then that is fine. Okay, let's stop right now. We're going to take a quick break, and then we're going to come back and finish up the 900 authentication and then 1000 best evidence rule. So we'll start back up in 5 minutes. Now for 900 authentication and the 900 series, this is for real and demonstrative evidence. So again, this is not testimonial evidence. Testimonial evidence is most stuff that we've been dealing with all other areas, but this is specifically for exhibits. So, bags of cocaine, murder weapon, photograph, contract, emails, a set of keys, DNA, x-rays, charts, maps, diagrams, all the stuff of the case. Remember, real evidence are the documents, the items that are part of the case, like the actual contract or the actual murder weapon, or letters or emails, or the offending patent infringement, whatever it may be, the actual stuff of the case. Demonstrative evidence or demonstrative exhibits will be exhibits that either an expert or most of the time the attorney, maybe sometimes with the help of the witnesses, will create diagrams or lists or photographs or even a computer animation or something that will help clarify testimony, or almost like a teaching aid for the jury that they create. And so that's what they mean by demonstrative evidence. Demonstrative meaning you're clarifying the testimony of somebody, where real evidence would be the actual surveillance camera photograph, for example. Okay, so for both of those, you need to provide foundation. What is foundation? Foundation is the initial showing that the evidence, whatever it is, the real or demonstrable evidence, the gun, the document, etc., is what it purports to be. It's the actual gun. So instead of taking the word of the lawyer or even of the witness that this is the document, this is the gun, this is the cocaine, you have to have some showing of evidence that the jury can make a rational determination, a rational decision, a logically based decision that it is what it purports to be. They're not guessing, and they're not relying on a guess. They're relying on actual evidence, and that evidence is what they're basing it on. And since they're basing it on that requisite showing of evidence, it's been come to be thought of as foundation. The foundation for belief that the gun is actually the gun. And it can't just be because the attorney says so. There has to be some showing of that. Now, it could be because a witness says so and they identify it, know it, and so you're going to believe it. Just like if the light is green, are you going to believe that the light is green? Well, you believe that the light is green, but there has to be some evidence upon which you base it. And it might be testimony from a witness who was there who said that the light was green. But at least now it's a rationally based decision. It's not just, well, okay, I'll take your word for it, attorney, that the light was green. Okay, so this process is called authentication. So just because something is authenticated does not mean it's automatically admissible. What it means is that it's just cleared the first hurdle, right? It still needs to be relevant. It still needs to not offend character. It still needs to not be hearsay, all of those things. but at least there won't be a foundation problem because you've provided evidence that if the jury wants to believe that the item is what it purports to be, they can base it on the evidence or the foundation you've given them that will allow for a logically based, rational decision. So again, it can be authenticated. That doesn't mean it's automatically admissible. Just like if we say something is relevant. Something is relevant is not automatically admissible. It could be relevant but be hearsay. So it's inadmissible because it's hearsay, even though it's relevant. You wouldn't say it's admissible because it's relevant. You would just say it's not going to be inadmissible because there's a relevancy problem. We've solved the relevancy problem. So as long as there are no other evidentiary problems, it will get in. Okay, so how do we lay foundation? Rule 901 A talks about that and how we could go about doing it. Let's do it with maybe a witness who saw it. Is the photo a fair and accurate representation of what happened? Is a witness familiar with handwriting, voice, methodology, etc.? Are there distinctive characteristics, right? Or is it a self-authenticating document, like a public records or a trade inscription? Okay, so these are just some of the methods. I throw those out there because under the rule, these are all illustrative ways. It's not exhaustive, but just an illustrative way to do it. So, looking at the specific rules then, 901B1, get a witness who is familiar with the letter. Let's say you want to lay foundation for a letter, look at 901B1, a witness who's familiar with it. Or 901B2, get a witness who's familiar with the handwriting or the signature on the letter. Or 901B4, get a witness who can point out distinctive characteristics about the letter that would identify the letter. Note that authentication is sometimes referred to as identification. It's the way in which you are identifying the exhibits and the evidence that you are providing that identifies the exhibits, so that if the jury wants to believe that the exhibit is what it purports to be, they have a rational basis for doing that. Okay, let's do example number 1. Here is a letter. And so what would you say if you're trying to lay foundation? And so just to give the kind of the exhibit walk of what you would say, referring court and counsel to what has been previously marked as whatever, 2 or People's 5 or Exhibit 6, whatever you would put for identification. Because at this point, it's not that the exhibit is admitted in and the clerk has their own numbers and letters for doing that. You can't disturb their numbering process, but you can do your own numbers as long as you say it's for identification for right now. Because if it's admissible, fine, it'll get a new number. If it's inadmissible, then we at least want to identify it if we ever appeal this particular issue, and we'd make an offer of proof, and then it would have the mark for identification on it. So, since it's not admitted at this point, referring court and counsel to what has been previously marked as number 5 for identification. May I approach the witness? Now, this is the older way of doing it. The newer way would be like this, where you have a computer, there's a computer screen where the witness, the jury has it, the judge has it, and so instead of approaching them, you would just say, if you could please look at your computer screen. But a lot of places, actually, surprisingly, in state courts don't have the computers, or they don't use them that much. So you would approach the witness, or you would at least tell them to look at the screen, and then say to them, Miss Crowley, and if this is Miss Crowley and this is her letter, we would ask certain questions. Okay, I'm showing you what has been marked as number 5 for identification. Do you recognize it? So I'm asking her, it's not a leading question, I'm just saying, do you recognize it? Because I want her to say yes, and when she says yes, I'll say, what is it? Now that you recognize it, tell us what it is. And then she can explain that it is a letter that was written by her to Tough Enough Sports or whoever, and she could say that it is her letter. And then I could say, how are you familiar with this letter? Then she can point to certain things, like the letterhead that has her initials. Or she would always put her own name and address at the top, and then the next part would be to the person that she addressed it to. She could also say, I'm familiar with the handwriting. That is my signature, and I recognize that. I also, maybe there are distinctive characteristics. I also recognize what the letter contains or what it's talking about, right? So 901B1, first of all, would be, this is Miss Crowley, this is someone who is familiar with the letter, has knowledge about the letter, and so they can be what is like your sponsoring witness for the foundation of the letter. Directing your attention to the signature on the bottom of the page. Do you recognize that signature? Yes. Whose signature is it? It's mine, blah, blah, blah. How are you familiar with it? Because I know my own signature, right? So now look what we have, 901B2. This is how they are familiar with their signature. And then you could continue laying foundation. Directing your attention to the letterhead at the top of the page. Do you recognize it? Yes. What did the initials stand for? MFC, which would be Mary Frederica Crowley. Those are my initials, blah, blah, blah. She could explain that. She could explain how she created this letterhead or whatever. Now, this is laying it on very thick. You don't need all of this, and I don't mean to imply that, but this is just a number of ways you can do it. And then now we have the 901B4 distinctive characteristics. You also can look at the contents. Are you familiar with the contents of the letter? Yes, I remember. Why are you familiar with the contents? Because I wrote the letter to them complaining. And so there we have the 901B4. Now, after you lay all of that, you're still not quite finished because you want to say, is this letter in substantially the same condition as when you sent it in April of 2013? We want to just make sure that this is what you sent, substantially the same condition. It's almost like saying fair and accurate representation, the same idea that, hey, if the jury wants to believe that this is your letter, then they have to have something to base it on, and we're laying the foundation thick for them to base it on it. Okay? And then when after all of that's done, you'd say, at this time, Your Honor, we move to have what has been marked as Exhibit number 5 for identification in evidence. Then, Your Honor would say, does the other side have any objections? And so we may have a number of objections to this. And this is how you spot issues. And so as we get to the end of this, I'd like you to think about those things, but maybe Rule 106 is there more to this letter? Are there exhibits? Are we ripping it out of context? What is the relevancy of this letter? What does it tend to prove? Is there legal relevancy to this letter? Even if there's probative value, is the probative value substantially outweighed by the danger of unfair prejudice? Or is it cumulative? Is there a danger of misleading the jury? Is it a delay or a waste of time? What about 404? Is there improper character? Maybe the substance of the letter, if you look at it, they're talking about Eric and the person and saying things about them. Maybe there's improper character, propensity evidence in there, and you can't do that under 404, right? It's a civil case, so you can't open the door. All of the things where you would go through and make the argument. What about the rest of 406 to 415? Maybe it's habit and it's okay. Maybe it's a subsequent remedial measure. Maybe it's part of a settlement conference. Maybe it's, they're offering to pay medical expenses. Maybe it's plea bargaining. Maybe there is some reference to liability insurance there. Maybe there's if it's a sexual harassment case, maybe there are some issues where they're attacking the victim's sexual behavior or predisposition. Is this a letter that was written to the attorney, so there's attorney-client privilege? Is this a letter that was written to a spouse, and so you want to have a marital communication confidentiality? Or is this spouse, maybe they'll elect not to testify against their other spouse, so that would be the spousal privilege. and you just keep on going. Is this witness competent to testify? Do they have personal knowledge, or are they just speculating? Is this improper lay opinion? Are there opinions in there? Is this person not qualified as an expert, yet they're trying to give expert testimony? Are they giving expert testimony in an area that isn't the proper subject matter of it? Are they basing their expert opinion on inadmissible evidence, which is okay to do, but you can't bring in the inadmissible evidence unless it satisfies the reverse 403 test, which the probative value of that inadmissible evidence substantially outweighs the danger of unfair prejudice. Is there any hearsay in it? Does it fit the definition of hearsay? If so, is there any hearsay exclusion, or is there any exception under 803 or 804B? What about the foundation? Although we've already just did that, so that wouldn't seem to be too much of a problem. And then sort of the last thing, which we will look at, the 1,000 rules, but if we're trying to prove the contents of the writing, do we have to have the original letter? Or is a duplicate of the letter okay? Or if we don't have an original or a duplicate, can we use secondary evidence? So some of the other things that come under the 1,000. All right? So when we do this, when you're dealing with laying foundation this way, make sure you can do that exhibit walk, where you get a witness with knowledge or a witness who's familiar with handwriting, an expert witness on handwriting maybe, or a witness who recognizes distinctive characteristics about the document. Those are the main ones. Now there are other ones for voice ID and incoming or outgoing telephone calls. And that's just to, say, do we have foundation for this person to be able to say that was the defendant's voice. I recognize their voice. Or that was the number I called and it went to their house and we talked on the phone. Those sorts of things. Now, we don't need a chain of custody necessarily for like the letter, because we can identify the letter through many other means. When you only need that chain of custody when it is something like a powdery cocaine, heroin, maybe even a gun that is mass-produced, and so there are no distinctive characteristics. Then you have to give some kind of distinctive characteristics so that we know it is the item that you took from the defendant at the time of the investigation. You put it away in a property envelope. It's been sealed. Nobody's tampered with it. There is like a library checkout card in case anyone has looked at it, and then it remains unsealed until the day it goes into court and gets opened. So, chain of custody goes to credibility, unless you absolutely have to have it for something like cocaine or a very fungible, interchangeable type of exhibit, where in order to be able to identify it, you have to give or assign it some unique characteristics. Now, don't forget about the timing involved for handwriting as opposed to voice IDs or other ones. Remember, if there is the smoking gun letter or memo or ransom note or whatever it is they wrote, and you have a witness who is familiar with the defendant's handwriting and you want them to identify it, the way that witness would have to identify the handwriting is because in time they would have become familiar with the defendant's handwriting beforehand. And then they're being asked today to identify that handwriting. They can do it as long as they developed their familiarity before the offending smoking gun letter or memo or ransom note. So they can authenticate it if they're already familiar with it. However, if the witness is only familiar later on, in other words, the defendant allegedly writes this ransom note, and then later a witness becomes familiar with the witness's handwriting, and then they say, hey, I can authenticate or identify that, the rule doesn't allow that. It's just a timing issue, and they say, no, sorry about that. But you're not left out in the cold. Rule 901B3 would say you can either get an expert to do after the fact handwriting analysis, or you can ask the jury to do after the fact handwriting analysis. So 901B2, a lay witness who's familiar with handwriting has to develop their familiarity before the offending memo or ransom note is written. Whereas if you use 901B3, an expert, or you're showing the exemplars and the offending letter or memo, that can be developed afterwards, and that's okay. But if you're a lay witness doing that, you wouldn't be able to do that. Okay, self-authenticating documents. This is just the idea where the foundation is already laid, in a sense. It's already built in to these kind of documents. And that is based on the official nature of the document. So when you look at 902, and it gives you 12 examples of very official types of documents that are maintained in official county buildings or city buildings or some state buildings, and they have official seals on them, deeds to property, things like that. Those are self-authenticating. Why? Because if the jury wants to believe those are what they purport to be, there's already built-in safeguards that they are what they purport to be. The fact that there's a seal, the maintenance of the documents in the official capacity of the state or the county of the city, they already have a built-in chain of custody. So all of these things are there. And so enough is there that if the jury chooses to find that the document is what it purports to be, there's enough there for them to say, we have that automatic self-authentication. So think of 902 as that. And again, there's no need for an attorney to lay foundation because the foundation is already laid. The reliability is already there. It's built in. So enough evidence, it's already there, that if the jury wants to believe it, there's enough there for them to believe it is what it purports to be. And so I would look at the examples in 902, but again, these are very official: trade inscription, newspaper, certain things that have enough indicia of reliability that we don't have to, that it wouldn't be the jury merely speculating wildly. There's enough in the document itself and in the official nature of the document that if the jury wants to believe it is what it purports to be, then there's enough there. Okay, now for demonstratives, make sure you make the distinction between the demonstratives and the regular exhibits, because with demonstratives, what we're saying is these exhibits are just helping me to clarify my testimony or what I'm saying. And again, they may or may not be admitted themselves as evidence. Often they are, even though they're demonstrative, but technically some judges will say, look, they're not evidence. They're just exhibits to clarify that which is evidence. And that which is evidence is the testimony. So if the testimony doesn't go back to the deliberation room, in other words, the court reporter's transcript doesn't go back to the court, to the deliberation room, neither should a demonstrative exhibit, because it is not evidence itself in the sense of the documentary form. The real evidence is the testimony, and the testimony has already been had, so we don't need to add anything to it. Okay, so this is the idea that demonstrative evidence really isn't evidence or proof at all. Now, some people say, well, no, the witness testimony is the evidence. The demonstrative exhibit just helps that testimony get explained. But others, and this is why judges will allow it sometimes, they'll say if the jury sees the exhibit may be communicating more information to the jury than simply what the witness said. So yes, there may be elements that the exhibit is clarifying testimony, but it also may be providing more information, even more evidence. You know, the idea that a picture is worth 1,000 words, or a diagram or a map, may be put in context. More is being communicated to the jury, so in a sense, it is evidence, not just the testimony. So judges grapple with that issue back and forth. Okay, I'm going to take 5 minutes, and then we're going to do the last 10 minutes here on the best evidence rule. Okay, now for the 1000 series, the writings, sometimes referred to as the best evidence rule. And so if the evidence is a writing, any kind of document, but it can also be a recording or a drawing, or it's a pretty broad definition of writing or document. But if that is what the evidence is, if it's that kind of exhibit, then you must produce the original, or at least a good excuse why you don't have it, or maybe a duplicate, as we'll see. Now, note that this seems to overlap with authentication because we're dealing with writings and documents. Don't confuse the two. It's very easy when you're talking about authentication to all of a sudden start talking about the best evidence rule. Keep the 900 authentication foundation questions and analysis very distinct from the 1000 writings rules, okay? So, note too that photocopies referred to as duplicates, they are often seen as okay. They're just a little bit of a qualification or limitation on those that we'll talk about. Okay, the best evidence or original document rule, and many people think that original document rule is a better descriptor of the rule, because best evidence, sometimes it confuses lawyers and attorneys. So maybe the original document rule, sort of when do you need the original document, is the better way of saying it. Also, emphasizing the fact that documents are defined as very broadly. Photos, diagrams, drawings, those are also considered to be documents. So even if they don't have printed words on them, if they have any kind of representation, or like a photo doesn't have written words, but it's still considered a document in this, or a writing in this very broad definition. Okay, so let's first go through the best evidence original document rule, kind of the definitions. 1001, a writing or recording, the words, symbols, or recordings of those. And these could be very, very broad. We saw in this case that we're going to look at the Lucasfilm, that it included, it was a Star Wars, the Emperor Strikes Back, and there were reconstructions of these Garthian striders. And so even though this wasn't a writing with words on it, it was a drawing, and the drawing was considered to be a writing. And so that could be, so writing or recording, very broad. 1001.2, photographs. Photos are considered a writing, and they fit within this. And those could be photographs, X-ray films, videotape. But of course, this is if these are being used substantively, not merely demonstratively, because as we'll see, the rule only applies when you're trying to prove the contents of the writing. If you're only using the writing demonstratively to clarify testimony, then the original document doesn't even apply. You don't need the original document, because the reliability is in the cross-examination of the eyewitness or the expert who is merely using the writing to clarify testimony. So, for example, if you have a photograph and you're trying to show that the photograph is an invasion of privacy, or maybe it offends obscenity laws or something like that, then you're trying to prove the contents of the writing or the photograph, and the rule would apply. So we'll see that when we get in there, but just now note that these are very broad definitions. 1001.3, the originals. Originals are the originals, the very one that you use that's intended as an original, or any counterpart intended as an original that'll have the same effect. So let's say there is a contract between me and 50 members of the class, and we write up one of the contracts, and everybody signs one of the contracts. Then we take the contract and make 50 copies, and then we say, here are 50 copies, here are 50 original copies. So instead of making you sign 50 times and me sign 50 times, we can make copies of them, but if they're intended as an original, then that would work. Also, let's say we have the original, we sign it all, and then with our 50 signatures on there, we do a PDF, and we scan the document. And then we give each PDF to you. Even that can be considered a original copy, right? Because it was intended as an original by the person who is duplicating it. And even if I send it to you as a PDF, you keep it there and then you print it out, that printout of the original PDF would be considered an original. So original can be defined very largely. Now, 1001 duplicates. That's a counterpart produced by the same impression as the original or photography. A lot of this is just intent. If I make the contract, I do the PDF, and we have 50 copies, and then the New York Times wants to get a copy of the contract, well, that's not intended as an original, so I could take a photocopy of my original, send them a copy, and now that would be a duplicate, even though you have what could be considered a duplicate, but in reality it would be considered an original because it was intended as an original. Okay, so those are the definitions. Now the hardest part of the rule is trying to define if the rule is even applicable. So let's do some examples to try to figure that out. Is the proponent of the evidence, if I'm offering, let's say, the contract, or I'm offering the writing or the recording or the drawing or whatever it is, are we offering this writing or recording, right? So this does not, say like I have a cell phone and I want to do the cell phone. Well, this is a tangible item and it wouldn't work. Although if there are documents within the cell phone or there are files within there, then maybe those would be subject to being a writing or recording. But the cell phone itself, or the DNA, or whatever, a set of keys, a wallet, it wouldn't apply to the physical evidence. So note the distinction there between authentication and best evidence rule. Authentication applies often or always to these tangible exhibits like a cell phone, DNA, a set of keys, a wallet. You have to lay foundation for all of that. But none of those would even apply to the best evidence rule because we're talking about a writing or a recording, even though that's defined very broadly to include like a voice recording, artwork, drawings, diagrams, that sort of things, not just like Word documents or an Excel spreadsheet. Okay, so there's the writing or recording, but we're not talking about physical evidence. And then second, and here's the hardest part of the rule, are we trying to prove the contents of the writing as a matter of law? Again, it's not being used merely as a demonstrative exhibit at all, but it's an independent act that there is merely a recording of it. That we don't want that either. In other words, if there's testimony about payment of a debt instead of the written receipt of payment, or a drug deal that is a tape recording thereof, are those subject to, we have to have the original? And the answer would be no, because as a matter of law, we can prove that somebody paid someone else the money they owed them with a witness who said, yeah, I saw him give him the $100. So even if a receipt is written for the $100, that receipt does not fall under, even though it's a writing or recording, it doesn't, you wouldn't have to use the original receipt to prove that. And even if there is a receipt, you could still use testimony from the witness. Now, if you and I write a contract and a witness sees the contract and I want to sue you on the contract and I don't produce the contract, I just produce the individual who was a witness to our contract, that's when the rule would apply. That'd say, no, sorry, you can't use that testimony. You got to use the original contract or a duplicate, or have a good argument as to why you don't have the original or a duplicate. But the rule would apply in those cases. But in cases where it's just payment and there's a receipt, we don't need that. Or it's a demonstrative exhibit, we don't need it. So the rule wouldn't even apply. Now, to go a little further with that, are we trying to prove the contents of the writing, photo, recording itself as an independent legal document? So when we have a contract, a will, a deed, those are the kind of things that we need to produce the original, or at least know that the rule applies where you need the original document, or you better have a good argument why you don't. Same thing if it's a film, photo, or drawing. If we're trying to show that this film was an invasion of privacy, well then, or it's obscene, or something like that, then we would have to show the actual. Or if it's artwork that was infringed upon, we would have to show that because it's the original film and you're trying to prove the contents of the case and you need the document as part of the legal element. Okay, now if there is simply documentary evidence of an act, like a receipt for payment, then the rule does not apply. So if a witness sees you getting paid off, but there's also there's that act of payment, but there's also a receipt, you don't need to say, hey, the original document rule applies, therefore you can't testify that he paid him the money, and you need an original copy of the receipt. You can use the original copy. You'd lay foundation for that copy, or because having a receipt gives you more evidence that you would want to use, but you don't have to use it. So this is why best evidence rule is an unfortunate name, because it seems like, well, the receipt is better evidence than just the witness saying he saw him get him paid off, so that means the best evidence rule must apply. No. Original document is the better rule, because you could say, all right, do we need the original document to make the legal claim? No. Is the original document helpful to us? Does it go to waste? Will the jury respect it more if we see that? Then, yeah, go ahead and use it, lay foundation for it, but you don't have to have it as a matter of law under the original document rule. Okay, so that's what Rule 102 is, that you have to use the original if you're trying to prove the contents of the writing. So a contract, will, or deed, you need the original, but not a receipt to prove payment, or not the original photo if used demonstratively. But if you're using the photo substantively, then you would have to do it. Remember when we did authentication, the surveillance camera photo, you would have to lay foundation for that surveillance camera photo, because there's not a witness there to say it's just a fair and accurate representation. So it would be that kind of thing. You'd have to use the original photo if you're using it substantively, but you could use a copy if you're just saying this is a fair and accurate representation of what the crime scene looked like when the defendant or when the witness was there and saw the defendant run over the plaintiff. Okay, so the most confusing aspect of the original document rule then is this issue right here, that the rule applies when you're proving the contents of a writing by using the writing itself. Okay, so there's another case we looked at, the GPS system finding findings, which were showing a trip from Mexico, you would have to use that if you're trying to prove that the person actually went to Mexico. But if there were a person that made the trip to Mexico and they could testify that they were there, but there was a GPS product or a GPS record that the boat went to Mexico, you wouldn't say, oh, you have to prove the GPS report. You could say the testimony that the person went to Mexico is good enough. However, if the witness never went to Mexico and now you're relying on the GPS system to prove that the boat went to Mexico, now you would need the original. But you wouldn't need the original if you had the witness there and then the witness was pointing to the GPS report as additional evidence and just to help clarify what the route was. Okay, so that's the toughest part of the rule. Now, if the rule applies, then you have to prove you have to use the original, or you can use duplicates. So I mean, they make this big deal that it has to be the original document, but once we determine that you have to have the original documents, we allow copies. Photocopies are fine too. Now, the only thing about photocopies is if there's a big issue, if the whole case is about fraud, so that there's a genuine question as to the authenticity of the original, or it would be unfair under the circumstances to put the duplicate in lieu of the original, then the court is not going to allow the duplicate. They want the original. So what this means is if the whole case turns on whether the contract is a fraud or not a fraud, then you need the original. But if the whole case turns on the contract and whether it was breached and whether the person had a right to breach it, where there's no real genuine question as to the authenticity of the original, it's okay to use a duplicate instead of the original document, because the authenticity is not really what the case is about. So it's okay, it would be okay to use a duplicate. Now, Rule 1004, admissibility of other evidence of the contents. Sometimes secondary evidence is okay. And sometimes secondary evidence can be used even if the original is supposed to be used. So, what happens if there's testimony or other non-original evidence? You can use it if, let's say the rule applies, it's a contract, but the original is lost or destroyed, and there's no bad faith as to why it was lost or destroyed. And we'll see this in the Lucasfilm case, that wasn't the case because they didn't have the originals. Although in the case they found that there's bad faith there, because if your whole idea of copywriting this is to keep it and then you conveniently lose them and then sue them afterwards, that's bad faith. So if there's no bad faith and they were just lost or destroyed, you could use secondary evidence, which would be testimony about the contract. So let's go back and do it. Like, if you're trying to prove the contents of a contract, the rule applies and you have to show the original. If you don't have the original, you could use the duplicates as long as there's no genuine issue as to the authenticity of the original, and in fairness, you should use the original instead of an alleged fraud copy. But if there's no issue like that, then a duplicate is okay. Let's say you don't have the original, nor do you have even a duplicate. You can use secondary evidence, testimony about it, if it wasn't lost or destroyed with bad faith. So one of the cases we'll look at is there's an insurance policy, which is a contract. And so it's a contract, we need to use the original, but we don't have it, and we don't have a duplicate, no copies were made. So can we use secondary evidence? Yes. Why? Because the fire policy was burned in the fire. They kept the fire policy in the office and it all burned and they didn't have it. And there was no bad faith, and so they could give secondary evidence, what they remember about it, and that would be okay because it was lost or destroyed. Or if you can't get it by reasonable due diligence, let's say it exists somewhere in North Korea and the North Koreans won't let you get to it, then that's okay. Or the other side has it and they won't produce it. You know, it's like you're suing for breach of contract and they say, all right, where's the contract? Well, I don't have it. And if the defendant has it, the defendant can't say, well, you have to produce it. The person would say, well, you have the original. Yeah, but you have to produce the original, your original. You can't use my original. Well, in that instance, if the other side has it and won't produce it, then you could use secondary evidence. Even though the rule applies, you don't have to produce it because that side already has a copy. Now, this one I love. We really don't need it anyway. It's just a side issue.